But it again just tells the story of it's the evil and the ugliness of people's hearts these days is everywhere.
This is Frankie Rose's Think Tank. Here's your host, Frankie Rose.
Hey guys, welcome to the Think Tank. Damn, I just love that. Great job, Mexi and Chooch. I have to thank you. So I'm not too sure if anybody who's been keeping up with, I think it's Georgia, right? Versus Teresa Black. Hey, Dandy, good to see you, friend. So they're on day 4 of this trial. And, I thought, why don't we take a look? I don't know a lot about this case, so we can learn together. So I thought I'll start with the morning session and we'll talk our way through it and see where we go from there. So this is a cold case from, I believe, somewhere around 20 years ago. And I'm pretty sure this is the mother. Let's see what happens here, guys. Let's learn together.
Able to do what? It's not displaying your. Well, I can do that. There.
Hey, Charlotte, good to see you. Candy.
Unplug and replug. I just did. Just now? Yes.
It's cold out here. So this must be our suspect. These people that are finally coming to justice, it's about time.
Well,
way too long people have thought they've gotten away with this kind of crap.
We'll see. We can go ahead and get started. We'll get IT here. But
Awesome.
Yes, Sharon, it's just we want tender exhibits.
I understand.
You guys
we'll
hear?
have to get started. It's already after 10 o'clock.
Can you guys hear everything okay? This is a first for me, so yeah, I like that we're basically learning together. A couple days behind, but I'm pretty sure we're going to catch up fast. Lizzie. To me, this is what it's all about, being able to watch and learn these proceedings. What's going on with Koberger, I just find mortifying. This is the way it should be.
Chris is on his way, but we're going to go ahead and
Lizzie.
go ahead and bring the jurors in.
Go ahead.
Oh my goodness.
I think all you have to do is call IT and it automatically sends something out to the sky to. All right, so it's working now. All right, well, we're not canceling it. We'll still just in case it'll probably stop working. Okay.
Thanks, Dandy. On flippin' real. I mean, Nothing should ever surprise us, right? But you know what? These crimes against kids, when it's the parents that are involved, I just I can't relate in any way, shape, or form. I think they deserve probably some of the more stiffest punishments that the law can provide. It is, Charlotte. It absolutely is. They just said jurors were in. She never reported him missing. She lied about his whereabouts to everyone and went back to her life for 23 years until Ava, she knew William, saw a rendering and gave him back.
Welcome back, everybody. Hope y'all had a nice weekend. And we are ready to proceed. All right, Nick, call your next witness.
You're on a state call investigator.
Okay.
Thanks for that update, Dandy, because literally this is my first at actually having time to look into this case. And I'll stick to it if you guys are interested. And it does, like I said, these are some of my favorite cases, the ones where they're able to go back and get this parent that was capable of this type of thing. If they're capable of that, what else are they capable of?
Raise your right hand. You swear or affirm the testimony to the court to be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
State and spell your name for the court.
It's Investigator McClendon. It's McLendon.
Good morning, Investigator McClendon.
Morning.
Where are you employed, sir?
Currently, I am the supervising investigator over the domestic violence and sexual assault unit here at the DeKalb County District Attorney's Office.
And how long have you been employed with the DeKalb County District Attorney's Office?
I've had two stints, one starting in May of 2017
What?
To September of 2018.
Oh,
At which point I went back to the police department. My second stint started in June of 2020 up until my current position.
And prior to serving as a supervising investigator of a domestic violence sexual assault unit, what unit were you assigned to?
I was assigned to the major case unit as an investigator.
And the major case unit, what type of cases do they deal with?
It's mostly homicides, and then we would do the complex armed robberies and gang cases.
And prior to, you kind of explained to the jury, serving as an investigator for a major felony, you were at the police department. What police department were you working for?
The DeKalb County Police Department.
And when you were, your last stint at DeKalb County Police Department, what was your rank?
I was a sergeant over the homicide unit.
I want to speak with you in reference to your work in 2022 with the major case unit. Can you please inform the jury what was your duties as a homicide as an investigator in our major felony unit?
Yes, when a jurisdiction within DeKalb County would make
Hey,
an
Mel.
arrest on a homicide, the case file would come to our unit. I would review the file for charging decisions with the assistant district attorneys and finalize any investigative leads that needed to be followed up on.
At some point while you were working with major felony, were you all also investigating cold cases?
I did, yes.
And can you explain to the jury some of the difficulties that you kind of had to deal with when investigating the cold cases here in DeKalb?
Well, this case was the first cold case that I believe that I investigated. There's been several after the fact, but the typical is, especially with the older.
what a disgusting human. Like, are you kidding me? And then you were saying that she had the gall to file for child support? Oh, oh, what? Oh, I don't even know what to say. Like, how? How can you? How can you?
The older the case is, your witnesses, sometimes they're deceased, being able to locate records going back several and many years. Sometimes evidence is lost, sometimes evidence is destroyed, and things like that.
I want to now speak with you in reference to
Yeah, destroyed.
this case that we're discussing here today. How did we become involved, or how did the district attorney's office become involved in this case?
Yes, the tip that went into NICMIC, the National Center of Exploited and Missing Children, came to our office.
And do you know who our office received that tip from?
The tip was reported to NICMIC by Ava.
And once the district attorney's office received the information or the tip from Ava, can you tell the jury, then what did the district attorney's office do?
When it came in, from my understanding, it went to our SAKI unit, which handles cold case sexual assault cases. They reviewed and investigated the case as far as they could, but it was ultimately turned over to myself to look into regards to furthering the investigation in the case.
I am
So
so
after
glad
the
they
case,
can
or the
look
case at hand came to the major felony case, at
technology.
some point, did you all reach out to the DeKalb County Police Department?
Yes, I coordinated with
Most of
DeKalb
the
County
time.
Police Department. Lieutenant Quigley was in homicide at the time. That was a unit that I had just left, coming over here to coordinate the interview with the potential mother, Teresa, out in Phoenix, and getting a DNA sample.
And prior to preparing to go out to Phoenix to get a DNA sample, did the SAKI unit or someone from our office go and speak to the potential father in this case?
Yes, they did.
And do you know whether or not someone within our office obtained Mr. William Hamilton DNA?
Yes, they did.
And was those DNA results back before you and Lieutenant Quigley coordinated to go to Arizona?
Yes, they were.
All right, so at some point, you and Detective Quigley went to Arizona. How do you all know that Arizona was where you needed to go to find the potential mother of this unidentified individual at that time?
Prior to, we
Heartbreaking.
conducted our research using databases we have access to where it was learned.
Like I said, like I don't even see how a person has a capability of doing this, like unaliving anybody or not being interested in helping somebody when they're in a position, let alone it being your child. You know, we all know as mothers, fathers, that they're what keep us going. We will do anything for our children. This is so against nature that I will never understand it, don't want to understand it. And every time I see it, I'm equally as mortified. It's just like, what the hell? Brutal.
Teresa Black was living in Arizona and coordinated with their, I believe it was their special victims unit to assist us in locating her.
The guy's got that cool hair, hey?
So you and Detective Quigley flew to Arizona. Did you all speak with the respective agencies in Arizona and coordinated and coordinated with them to pick up Teresa and bring her to the police station?
Yes, we did.
And Teresa was brought to the police station based off the policies and procedures that Arizona Police Department had in place, or Phoenix Police Department has in place.
Yes.
Prior to speaking with Teresa, at some point did you or Detective Quigley secure a search warrant to obtain DNA from Teresa Black?
Yes, we coordinated with a detective from the Phoenix Police Department who secured that warrant on our behalf.
While in Phoenix, you and Lieutenant Quigley conducted an interview with Teresa. I want you to kind of explain to this jury, how do detectives build rapport and interview tactics with individuals to make them feel comfortable in order to provide a statement?
I mean, that's basically it. I mean, you're trying to show sympathy to this person, get on their level of emotion, to build that rapport with them, to make them comfortable, to be able to speak with you, because you're talking about two strangers coming from another state, coming to talk to somebody. That's what our effort is try to get them comfortable, get them understanding to where they will open up and where they will speak with us.
And is that kind of the interview tactic that you and Lieutenant Quigley used when you all interviewed Teresa Black?
Yes, ma'am.
Were you all able to obtain Teresa's Black DNA?
Yes, we were.
After you all obtained, well, let me ask you this. When did you all go to Arizona to obtain DNA from Teresa Black?
I believe we flew in on February 14th and our interview was on February the 15th.
Was that in 2022?
2022, yes, ma'am.
Did your investigation end after you obtained the DNA, after you obtained Teresa's Black DNA?
No, it did not.
When you all got back to Georgia, can you explain whether or not you continue to work at side by side with Lieutenant Quigley, or did you continue on this investigation without Lieutenant Quigley?
After we got back from Arizona, I basically took over that part of the investigation.
At some point, did you begin to review the file and track down any witnesses, or begin to track down any witnesses?
Yes, I did.
I want to speak with you in reference to Mr. Price and Mr. Carter, the two individuals that discovered the body of William Hamilton. Do you know their whereabouts today?
They are both deceased.
There were a large number of law enforcement officers on this case. Were you able to discover the whereabouts of some of the law enforcement officers on this case?
Yes, I was able to locate some of them. However, just like with some of the witnesses in that case, some of the officers had two passed away.
During your
Now,
investigation, did you
very
learn
much.
whether or not Teresa obtained any type of identification from the state of Georgia?
I
Yes,
appreciate
she
you.
had a Georgia identification card issued to her back in 1999.
May I approach?
Yes.
I am showing you what's been marked as States Exhibit 80 for identification purposes. Investigator McClendon, can you tell the jurors what's depicted in States Exhibit 80?
Yes, this is a printout of the identification card for Teresa Black from 1999.
Is this a fair and accurate depiction of Teresa Ann Bailey's?
I'm not sure what that is. Zygomatic arch. There's trauma to the zygomatic arch. Oh, aka the cheekbone. Gotcha. Oh my God. These cases with these kids, heart-wrenching.
Also known as Teresa Black identification card. Is it a fair and accurate depiction?
Yes, it is.
Your Honor, at this time, the state will tell what's been marked as States Exhibit 80.
80?
Yes, ma'am.
Any objection?
No objection.
It'll be a minute. Commissioner Department, you're on.
Sure. Is it working?
Should be. Investigator McClain, I don't know if you're able to see that, so I'm gonna show you things in 18. Can you tell this jurors the date that this identification was obtained?
Yes, the issue date was June 23rd, 1999.
June 23rd. And what is the address on this identification?
It's 1039 Marietta Street Northwest, Atlanta, Georgia. Zip code is 30318.
And what was significant about this address that you discovered during your investigation?
When doing research on that address, it was determined that they used to be the Atlanta Women's Day Shelter.
And during your investigation, did you come to learn how individuals are able to use the address for the Atlanta Women's Day Shelter?
I did. They were just able to use that address for reasons to get a ID or for their an ID card for their carrier.
And is the Atlanta Women's Day Shelter still located at this address?
No, it is not.
What's currently in its place?
Currently, it's a residential.
So can you kind of give us an explanation or tell us who exactly Ava is? I personally don't know, and it sounds like she could possibly be a hero.
I believe like an apartment complex or condominium.
And did you attempt to reach out to the Atlanta Women's Day Shelter to see if they had any records in regards to Miss Teresa Ann Bailey staying at that Women's Day Shelter?
Yes, I attempted, but was advised that no records existed dating back that long, and that they, under Georgia law, they were only required to keep records back dating back 7 years.
You were not able to obtain any records?
No.
I want to speak with you about William Deshaun Hamilton. Once we were able to obtain potential identification of the body found in the woods near Clifton Springs and Clifton Church Road, were you able to obtain a certificate of birth on William Deshaun Hamilton?
Yes, there was.
May I approach your honor? Yes. I'm sure you've been marked as State's Exhibit 81. Please advise the jury what's depicted in State's Exhibit 81.
It is the certificate of birth for William Deshaun Hamilton with the parents William Harris Hamilton and Teresa.
Was she a dancer when
Your Honor, at this
this
time, the
happened?
state would like to tender certified copy of the birth certificate of William Deshaun Hamilton in State's Exhibit 81.
Any objection?
No objection.
Submitted.
All right.
What is Mr. Hamilton's date of birth?
William Deshaun Hamilton's date of birth is June 23rd, 1992.
And I'm sorry, what was the date on the identification that Teresa Ann Bailey at the time got in Georgia?
June 23rd, 1999.
At the time that
William Hamilton was born, what was the age of Teresa Ann Bailey?
She was 15.
And what was the age of William Harris Hamilton?
18.
And do you recall Teresa Ann Bailey's, also known as Teresa Black, date of birth?
6/11/1977.
So it sounds like there's people that knew what she was up to. She was dancing after his disappearance, but not sure about when she was.
During your
close to
investigation,
Ava.
did you learn whether or not Mr. William Deshaun Hamilton was ever enrolled in any school system?
He was.
And do you recall what city or state that he was enrolled in? Where he was enrolled in school?
Yes, it was in North Carolina, the Mecklenburg County School District.
Did you attempt to obtain his school records?
Yes, our office received his records.
It is, it's heartbreaking.
Madam Mayor, I approach.
Yes.
I'm showing you what's been marked as State's Exhibit 82 for identification purposes. Can you explain to the jury what's depicted in State's Exhibit 82?
I just love this guy's hair. I wish I had those curls.
Yes, it's the school records our office received for William Deshaun Hamilton from Smithfield Elementary School.
It's a fair, accurate depiction of the records that our office received in reference to William Deshaun Hamilton's school records.
Yes.
You're at the time State wishes to tender State's Exhibit 82. I believe this is one of the stipulations that State and Defense agreed to as to its authenticity.
Any objection?
No objection, we stipulated.
All right, they're admitted without objection.
All right, so I want to show you, let's talk about the records.
It has on here that William Deshaun
I was
Hamilton
just
attended
going
Smithfield
to ask,
School.
friend.
Do you see the contact
Okay.
person for Mr. William Deshaun Hamilton?
Yes, under the student information section, the contact is
No.
Hamilton William, presumably William Hamilton, the father.
And it has the child's birthday, correct?
Yes,
And what, does it have a withdrawal date on here?
it does, of December 1st, 1998.
I want to go to the second page. What is shown in the middle in reference to the immunization of William Deshaun Hamilton?
This is showing the dates and the immunizations that he received.
All right, and below that, it has attendance information. Can you tell the jurors during first grade, how many days was Mr. Hamilton present?
62.
And how many days was he absent?
4.
Did you attempt to locate any kind of school records here in Georgia?
I don't recall doing so.
Did you ever come to learn whether or not he was ever enrolled in any school system here in Georgia?
Your Honor, I'm going to object on hearsay. He said he didn't look into them personally. Any other knowledge of hearsay?
No way.
Your Honor, I don't think it's hearsay. I think it's gonna be, effect on the listener if he was able to obtain any documents.
Well, he didn't look for any.
Yes, and also defense, she also stated herself, so it's gonna be a statement as a party opponent that he was never enrolled in school.
All right, were you able to identify any records
In the state of Georgia.
in Georgia?
I was not that.
Okay.
So at some point you began to do additional investigation in Charlotte. At some point, did you ever go out to Charlotte, North Carolina in reference to this case?
I did.
Roughly, when did you go to Charlotte?
I believe it was in May of 2022.
And while you were in
So
Charlotte,
you
can
turn it
explain to the
around or
jury
turn them down,
what you were
and then you
able
put the
to,
life down, like
what kind of evidence you were able to discover?
While we were in
twisted
Charlotte, we met with
beyond
Ava,
belief.
spoke with her about the case, met with the paternal side of William Hamilton's family, spoke with family members there. Based on speaking with Ava, I was able to identify Miles, was able to speak to him while we were there, and also was able to identify Montequilla Davis, the daycare provider. Learned she was living in Raleigh, North Carolina at the time of my visit.
At some point, were you able to make contact with Tina?
I was. By phone.
And when you were out during your investigation in Charlotte, was Lieutenant Quigley with you at that time?
He was not.
While you were also in Charlotte, did you learn of any type of communication between anyone on the paternal side of the family with Teresa?
Yes, I learned that Wanda and Teresa communicated through Facebook.
Did you do any research in reference to Facebook records?
I did. I was able to ascertain both accounts and apply and was granted search warrants for both accounts for Teresa Black and Wanda Hamilton.
Wanda. Did you guys see that the house that Leilani Simon was in is up for sale?
I want to show you the marked as State's Exhibit 83 and 84 for identification purposes. Can you explain to the jury what's depicted in State's Exhibit 83 and State's Exhibit 84?
State's Exhibit 83 is a certificate of authenticity from Facebook for Wanda Hamilton's account, and State's Exhibit 84 is a screenshot of a conversation from Wanda Hamilton's account.
I'm going to show you the marked as State's Exhibit 85 and State's Exhibit.
That's what I was wondering.
For identification purposes. Can you please tell the jury what's depicted in State's in those exhibits?
Yes, 85 is the certificate of authenticity from Facebook regarding Teresa Black's Facebook account, and 86 is a screenshot from Teresa Black's, or a screenshot of the conversation from Teresa Black's account.
Your Honor, at the time the state would wish to tender State's Exhibit 83 through 86, 83. Go ahead.
Very good question, friend. Like, what the hell, man? Holy. Huh. I do. I think there's a special place in hell.
I want to show you already been tendered into evidence in State's Exhibit 76. Do you recall what's in State's Exhibit 76?
There's a screenshot showing the main page for Wanda Hamilton's Facebook account.
And
Wanda
State's Exhibit
Hamilton.
77.
Same thing as the screenshot of the homepage for Teresa Black's account.
What? Jeez.
So were these, the Facebook records that you were able to obtain was based off these two profiles, Wanda Hamilton Houston? Is that correct?
Yes, ma'am.
Okay, who, okay.
And the other
Was she
profile was
involved?
labeled what name?
Teresa Black.
Or is this both her? Who's Wanda?
Can you see that on the screen, Investigator McClendon? Are you able to see that?
Yes, ma'am.
All right, I want to direct you to the exhibit on the screen. What is the event date? When does this conversation start?
Okay,
April
gotcha.
13th, 2017.
And in reference
Okay.
to this conversation, who is the author located? Who is the first author in this conversation?
On this page, it appears that the first author is Wanda Hamilton Houston.
Look at the very top page, the very top. Who is it says as the author?
Teresa Black.
And when you
So does she do, I guess we're gonna find out here right away. What Wanda know. Hey lady, how are you doing, boo? So is she involved?
go down to the second set after the author, scent, and body, there is another author right after that. Now, who is that author?
That would be Wanda Hamilton Houston.
Okay, Dandy.
And so is this conversation taking place between the Facebook accounts of Wanda Hamilton Houston and Teresa Black?
It is.
I want to direct you to a specific conversation within this conversation.
Whoa.
I want to go down to 1, 2, 3, 4, 5.
They talked a lot, huh?
The fifth paragraph where Wanda Hamilton Houston is the author. Can you read to the jury what's in the body?
She writes, "Thank you. She beautiful. So how my nephew doing? I would love to see you all."
And then what was the response in a subsequent paragraph
Oh,
where the
okay.
author is Teresa Black?
Teresa Black responds, "He is good. He has 2 kids. I'll give him your number. We live in Alaska, but moving to Arizona in May with my fiance."
And what is the date and time that
Hmm.
that message was sent by Teresa Black?
April 13th, 2017 at 6:15 p.m. That's in UTC time.
Hmm.
And in State's Exhibit 84, which is from Wanda Hamilton's account, is that the exact same conversation depicted that we just read pertaining to Teresa Black's account?
It is.
No. Are you kidding me? Oh, the sick woman. Biatch. My mouth wants to say different things. I am stumbling here. Like, what the hell? Oh. Yeah, they want to do the action, but you know,
Within the same
don't want to deal
conversation,
with it afterwards. Coward.
can you read the paragraph that starts with congrats on your engagement?
So this is
Unreal.
from one of Hamilton's. Congrats on your engagement. I am so happy for you and your. I would love to hear from my nephew. And you, do William, have a Facebook page?
And what was Teresa Black's response?
There's no response on this page.
Wow. Brutal.
And then at some point, even without a response, does Ms. Hamilton continue to send messages to Teresa Black?
She does.
And what is her next response or next message?
One is next message is send some pictures of you. Here's some picture of my kids and grandkids.
1000%.
And then at that point, does Ms. Hamilton proceed to send photos?
Yes, she sends 4 photos.
And is there a response from Teresa Black?
I don't believe so.
Yeah.
While also
Exactly.
in North Carolina, did you attempt to obtain any records from DFACS in reference to William Deshaun Hamilton?
Yes, it wasn't while I was in North Carolina, but through the investigation, I did attempt to obtain defects records through Mecklenburg County, North Carolina, and here in DeKalb County, Georgia.
That actually kind of feels very much like Letitia, something Letitia would pull. This is like one sick biatch who can do this to anyone, let alone your own child. And then the games afterwards? No. I guess, you know, we're just different than these aren't humans. This is not how people act.
And learned that there were no records dating back to that time frame.
Oh.
Did you come to know a place where Teresa may have been employed while she was here in DeKalb County, or I'm sorry, here in Georgia?
Yes, pleasers.
And did you attempt to contact her previous employer?
Because that's normal. Oh
Yeah,
my
business
God.
been closed for many years. The owner is deceased. I was unable to locate any records, or they did not keep any records from back in the day.
And so there was some point where you attempted to also see if Ms. Black got her liquor license in order to become an exotic dancer. How successful were you with that?
Again, no record could be found with, that would have been the Atlanta Police Department going back that far.
During your investigation, did you ever learn whether or not William Hamilton was reported missing?
I was not able to.
Oh my God, this freaking woman, man.
And so during this investigation, at some point in time, was a tip line created by the district attorney's office in reference to this case?
Yes, we did, which led to Gary Harris and the Luquise Black calling in and leaving messages.
And were they subsequently interviewed after obtaining their messages from the tip line?
Yes, they were.
How was this tip line disseminated to the public?
It was through local news broadcasts and through social media.
During your investigation, did you come to know or come to learn any information in reference to Teresa Black's parents?
Yes, her father was Leroy Clyburn and her mother was Willie Clyburn.
And what did you come to learn about their whereabouts?
Both are deceased.
I want to speak with you about her mother first, Willie Claiborne. Do you recall when she passed away?
I believe it was in November of 1999, the exact date I can't recall.
1999?
1995.
All right. And approximately how old was she at the time she passed away?
I believe she was 48.
And did you come to learn the whereabouts of Leroy Claiborne?
He is also deceased.
And do you recall approximately when he
What?
passed away?
I believe that was in 2007.
Do you know how old was Leroy Claiborne at the time Teresa moved to Atlanta?
I believe he was 54, around there.
The webs we weave when we practice to deceive.
During your time investigating this case, were you able or did you seek records from the Internal Revenue Service of Teresa's income taxes?
I did, and again, learned that the records were not held for going back that long.
Did you attempt to search for any unemployment records with North Carolina regarding Teresa?
I did, and I was advised no records could be located going back that far.
Upon learning information from William Hamilton in reference to child support being taken out of his checks, did you attempt to contact any child support office in North Carolina?
I did. I was able to learn that a case was open between the two parties in
I'm going to
2002.
object to this.
Basis,
Hearsay.
response?
Your Honor, this is not hearsay. This is actually effect on the listener. This is the investigator investigating the case, trying to figure out, corroborate other items that were already mentioned in this case, and he was doing his investigative work in order to.
Yes, ma'am.
This was an investigative work.
That doesn't make it non-hearsay.
Yes, Your Honor, but it's the effect on the listener, which makes it
Well, all
non-testimonial.
right, then rephrase the question so you can establish that.
Your Honor, my objection is it has to have an effect on him.
Right,
not just-
that's what I said, she needs to rephrase the question to set up the effect on your.
Were you able to obtain any child support records from North Carolina?
No, I was not.
Just if they can do this, what else are they capable of? And how safe would she be around other children? I swear that guy's got the best hair ever. Wrong color, right style. Her parents are both gone, but were alive when she did this. To William, she claims to have had no help.
I'm showing you investigative McClendon what's been marked as State's Exhibit 82 and has already been tendered into evidence. I want to point out to you a couple of locations. First off, Have you ever had an opportunity to review this exhibit?
Yes, I have.
Oh, really?
So can
Oh,
you point, I guess, on the screen behind you where the city of Decatur is located?
This area up here.
And where is the Atlanta Women Day Shelter back in 1998, 1999?
1039 Marietta Street.
And where was Club Pleasers located around 1998, 1999 on this map?
Down
That's
here
a
at
handle.
849 Cleveland Avenue.
And then the incident location, approximately where William Hamilton's body was found.
In this area right here, the address to the church across the street was 2918 Clifton Church Road.
During your investigation, were you able to
good question.
investigate
Mel.
the approximate distance and times that a person can get from either of these locations, either from the Atlanta Women's Day Shelter to Clifton Springs and or from Pleasers to Clifton Springs?
I'm not quite sure I understand.
Okay. During your investigation, did you go out to these locations?
I did.
Were you able to learn the approximate time it took you to get from the Atlanta Women's Day Shelter to Clifton Springs?
By car, I believe it was around 30 minutes, 30 to 40 minutes.
And at some point, did you learn the approximate time it took you to get from Pleasers to Clifton Springs?
By car, I believe it was around 20 minutes, 15, 20 minutes.
So it seems like this is all happening in a pretty small area. So again, back then they wouldn't even have all the cameras that we have access to right now. It'd be a lot different than a case the way they turn over now. But like I was saying earlier, I think it's great that DNA and all of these things have gotten to a point where we can literally go back and get the bad guy. I mean, nice. Because they need to pay. I don't care, 2 years, 20 years, 100 years. In my opinion.
While you and Lieutenant Quigley was in Arizona, did you all make any charging decisions at that time in reference to Miss Teresa Black?
No.
Was there any arrest made while you and Detective Quigley was in Arizona?
No.
After you completed additional investigation after Arizona, at some point did you ultimately present this case before a grand jury?
Yes, in June of 2022.
And that is roughly how many years had passed since the finding of William Deshaun Hamilton?
A little over 23.
Come on, Your Honor.
Thanks, Dandy. Discord link is in the description if anybody wants to join us. It's a great platform.
Investigator McClendon, at the crime scene, there was a can located right under the leg of William Deshaun. This has already been tendered in as State's Exhibit 23.
Ultimately, was this can retrieved and taken in for testing to the GBI?
Yes, it was taken in, but I don't believe it was sent to the GBI because it was a private lab.
Sent to a private lab. And what was the purpose of sending this can to the private lab?
To test the inside of it for any known drugs or narcotics.
And do you recall the reason why it was suspected that narcotics could have possibly been in this can?
Based on the toxicology report for William Hamilton.
And was there any illicit drugs found within this can?
No.
And Your Honor, at this time, the state will ask that you read the stipulation that has been tendered by both parties in reference to the can that was found.
All right. Again, ladies and gentlemen, a stipulation is a fact that both parties have agreed to, and it is considered as evidence, just like any testimony or any, or as if someone had testified to this fact. Stipulation number 2, an aluminum can labeled "very fine fruit punch" recovered near the child's remains was submitted to NMS Labs on April 12, 2022 for toxicological screening. The testing did not identify the presence of any known substance.
No additional question, Your Honor.
All right, cross.
Good morning.
Morning, sir.
I'd like to start, Investigator McClendon, with your conversation with Ava McNeil. You had a conversation with her, correct?
Yes,
And it was on April 1st of 2022, is that right?
I believe that was we had a Zoom meeting with her prior to going out to Charlotte.
All right, and you participated in that,
Yes,
and you wrote a report after your participation in that meeting?
yes,
Okay. Do you recall that Ava mentioned having a conversation with Teresa from what she believed was a payphone in Atlanta, right?
yes, I remember that.
Do you recall that Ava told you that that was about 3 days after Teresa left Charlotte?
I'd have to review my.
Would you like to?
Give you a date, yes, sir.
Okay. Automatic approach?
Sure.
It seems like they've got her pretty much nailed down.
Recollections refreshed.
Yes, Ava stated it was 3 days after she left.
And did she ever say that she spoke with Teresa again while she was in Atlanta?
I don't think she did.
In fact, she told you that she didn't speak to her until she got back to North Carolina, right?
I believe yes.
Now, it's your understanding Ava wasn't sure where Teresa was at in Atlanta, correct?
Correct.
The picture of the identification that was shown in evidence earlier, that was issued in June of 1999, right?
Yes, sir.
Were there any other Georgia IDs issued to Miss Black?
Not that I was able to locate.
The Facebook conversation between Wanda Hamilton and Teresa. In that conversation, where does Teresa say she's living at the time?
I believe it was Alaska.
Investigator McClendon, are we able to get, is there any records out there that give us any evidence about when Teresa was working at Pleasers?
No,
In your conversation with Teresa, did she mention that she was working there for a long time or a little bit of time?
I can't recall the time she said.
All right. Are there any records that give us any evidence that placed Teresa at the Women's Day Shelter before that Georgia ID date of June 23rd, 1999?
No, sir.
Did Teresa ever mention to you in her statement that she and William stayed at that Clifton Church area more than one time?
No.
That's all I have. Thank you.
Can you redirect? No, Your Honor. Okay. Thank you so much. May you be excused? Yes, Your Honor. All right. Feel free to go.
So what, the defense next?
There are two additional stipulations on here that I did not believe have been read, stipulations 3 and 4.
And I believe they were to the admissibility of documents that have been admitted, Your Honor.
Okay. All right. Any other evidence or witnesses for the state?
No, Your Honor, the state rests.
All right. Ladies and gentlemen, there are some legal matters that I need to take up with the attorneys outside of your presence now that the state has rested its case. So I'm going to send you back to the jury room for a few moments, and we'll call you out as soon as we're ready.
So it looks like they will. They'll go straight over to the defense in a few minutes, which is nice.
I mean, or from the defense, sorry.
Yes, sure.
Okay.
Your Honor, at this time, the defense moves for a directed verdict on all counts. And I would like to give some particularity to each charge. Your Honor, I first want to start off with, at the beginning, count 1 is felony murder.
Here we go.
That Teresa Black did cause the death of William Hamilton while in the commission of cruelty to children for not seeking medical treatment. So I think it's important to continue to think of these two as a pair. This cruelty goes with this felony murder. We heard evidence from Dr. Gowett.
So I don't know how much we have we'd missed. So Dandy's given us a bit of an update as we've been going through. So from what I've seen, which is very brief, obviously, we've only been streaming for about an hour. And some of the comments that Dandy's put out there and some of the characters or some of the people involved, sounds like they may have their woman. So, 20 years, a child. Yeah, like I said, there's a special place in hell for these people. I'm sure of it.
The doctor who performed the autopsy on William in 1999. Dr. Gowett cannot say what caused William's death. And importantly, the reason why that is important is Dr. Gowett cannot give any evidence that William needed medical treatment that would have been apparent to Teresa. Teresa is only guilty of this charge if she acted maliciously, meaning with the intent in the cruelty to children charge, with the intent to cause that severe injury.
I don't know, it was looking like intent.
She acted, or she denied him the medical treatment while there was a substantial likelihood that severe injury would happen. Dr. Gowett can't tell anyone if severe pain, physical or mental, even happened, if Teresa would have even been aware of anything that was happening. There is absolutely no evidence to suggest that William did.
So literally, is her defense, is she saying that my defense is I left him with a homeless person? That's her defense? Am I understanding this right?
Experience any cruel or excessive physical or mental pain, much less Teresa Black's intention. There is no evidence that she committed cruelty to children by not seeking medical treatment, because we have no evidence that she needed to seek medical treatment. If there's not enough evidence to suggest that cruelty, there's certainly not enough evidence to suggest this felony murder that's attached to. Additionally, we don't know if this caused his death. You can believe that she didn't seek medical treatment and it was causing him some sort of pain, but you have to have some evidence to suggest that that thing that she should have taken him to the hospital for is what caused him death. There has been no manner of death ruled here. Dr. Gowitt doesn't know what caused the death. There is no evidence to suggest one thing over any other. I had him on cross. We could have gone for 2 hours through a medical encyclopedia. No one wanted that. But when your symptoms are nausea and feeling lethargic, it could have been a huge list of things that either he should have been taken to the hospital for or things he shouldn't have. So there's no evidence at all that Teresa committed cruelty to children in the first degree by not seeking medical treatment, and certainly no evidence that that caused the death of William Hamilton. Count 3 and 4, I'll start with 4. This is the cruelty to children for administering a substance or substances containing diphenhydramine and acetaminophen to William Hamilton. I won't belabor this. We've heard so much in the Daubert hearing about what this means, but as far as evidence is concerned, there has not been, and there never will be, a single expert or witness that can say there's any evidence that William received a toxic or a lethal dose any more than there's evidence that he received a trace or therapeutic dose. If it's a trace or therapeutic dose, that does not cause injury, does not cause substantial pain, physical or mental, to William. There's no evidence pointing us in that in any direction at all. The only thing we know is he was exposed to these substances at least once. That is what Dr. Jackson kept insisting. Again, even if he was exposed to these and it caused him some sort of pain, there's no evidence to suggest that is what caused his death. No doctor will ever be able to say that. The aggravated assault charge, Your Honor, I think is really clear in the evidence that has been presented. Dr. Gowitt, the anthropologist that Dr. Gowitt has relied on, and Dr. Tice have all expressed the evidence of animal scavenging. The only time that anyone has said it's possible this is perimortem, meaning cause at around the time of death, was Dr. Tice's last report on December 13th. And it's possible. There is no evidence pointing in that direction. And in fact, all of the evidence is pointed towards the opposite. That is what the forensic anthropologist said in 2013, that this was animal scavenging. Dr. Gowitt saw that, said that is what they believed. Dr. Gowitt has no idea what caused this injury. There is
Which injuries?
the zygomatic arch,
Okay.
I'm sorry.
Fracture.
That's correct.
Okay.
And she's being charged here with striking the child in the head. So any of the injuries on the jaw or on the zygomatic arch, there has not been a single piece of evidence to suggest that Teresa struck William in the head. There never will be. The only thing that we can say is there is some damage. And every anthropologist or doctor that's looked at it says the evidence points to this being post-mortem trauma, likely due to animal scavenging. Finally, Your Honor, the concealing of death of another. She is charged with concealing the death of another for doing 2 different things. First, she's charged with concealing the death by leaving the body of William Hamilton in a wooded area. The second is for lying about his whereabouts. There are 34 cases that have been appealed and opinions written citing the concealing the death of another charge. There is not a single case that is
What? Oh,
there was
man.
sufficient evidence for wherever the body lies and is found later that that's enough evidence. In all 34 cases, the person charged has taken some sort of deliberate action. It's typical that the cases involve burning of the bodies or burning of a car or a house that has the body in it, moving the body from the crime scene to a remote location, covering the body with blankets or clothing to conceal, burying the body. There's also lines of cases where the defendants mislead or threaten that you cannot, if you tell someone that I killed this person, I'll kill you too. Every case takes a deliberate act to conceal. Now, leaving the body of William Hamilton in a wooded area, I think there's a couple of ways we can read that. We can read it as he passed away and she walked away. She left his body in a wooded area. That is not concealing. There is no act of concealment. And the expert or the people that went to the scene said there was no apparent attempt to conceal. He wasn't buried in leaves. He wasn't buried in the dirt. Another way to read that is she left him, as in she dumped him. That, if there was evidence of that, I would agree that could be concealing. Taking him after he is deceased to the wooded area.
All right, so let me ask you this. What is the difference between taking him to the wooded area and leaving the body versus waking up in the morning in the woods with him being dead and then walking away and leaving him there?
But it's a significant difference. One is that she moved the
I don't
body
know, buddy.
to further conceal it. It would be just like if you shot someone in your home and then you took them out into the desert, that is concealing. That's removing them from the crime scene.
But if you shoot somebody in the desert and just leave them there for the elements for months and never tell anybody about it, that's not concealing.
No. And if it was, there's no separate crime there between that and murder. Any murder in a remote location would be concealing. It's not. It's a separate offense. It's a separate action. It involves the act of concealing. So
She did say at some point that after she realized he was dead, she covered him up.
Semantics. Right.
but I believe that was also in reference to him being cold. I don't think it was after he was deceased. There certainly wasn't a jacket found at the scene. There was no evidence of that.
You wearing a hoodie or something?
As clothing.
Okay.
The lying portion, Your Honor, that it would be concealed. That is an act. However, there's a venue problem here. There is no evidence that Teresa committed that act, those lies, while in DeKalb County. She did it in Charlotte. She did it in Alaska. She did it to police in Arizona. The only conversation anyone had with her while she was in Atlanta about William was a conversation with Ava about 3 days after she left.
Right.
I don't think there's any evidence that William was already deceased, and they still have to show that happened in DeKalb County. We don't know where that payphone was at. There is no evidence here that's pointing to
Very
Teresa
good question.
saying any lie to anyone while she was in DeKalb County. So both prongs of that, there is no evidence of that. The first, there was no deliberate act to conceal. The second, and I want to address that again, the deliberate act, I imagine the state's going to point towards maybe Gary Harris saying that was evidence of someone dumping a body. He didn't see anyone. He doesn't know what was happening. He saw two people get into a car at the cemetery. That is not enough evidence to sustain this past a directed verdict. So for all the reasons, Your Honor, and I'd be happy to answer any other questions the court may have, the defense moves for a directed verdict on all counts.
Response?
Your Honor, I'll start with the concealing the death count. Even the mere fact of leaving a dead child in the woods in a secluded area where he will not be seen is an affirmative act that would operate to both conceal the death and hinder law enforcement's ability to discover that a death has occurred. So even if that is the only theory, the elements would be established by the
That was
mere
like
fact
verbal
that she left
diarrhea.
her dead child in the woods in a secluded area that absolutely prevented law enforcement from discovering that he was dead, from pursuing an investigation, and from collecting necessary evidence at those early stages before the child's remains had decomposed. Additionally, the state's theory is that Ms. Black actually used this site as a dump ground, that she, with someone, unidentified person, drove this child there and dumped his body, hiding him in the woods, which has been established through the fact that Ms. Black had no connection to this community, that there were no businesses or resources available, that she was new to the area, that William died pretty quickly after he got there.
So, all right, so what's, I'm sorry.
Are you serious?
Somebody.
What the hell? Can this all be proved?
I mean, I thought she said in her statement that they were there sleeping, he didn't wake up, she left him there, she put a jacket on him, and that was it.
That's Teresa's statement, absolutely, Your Honor, but we don't think it's credible. We don't think a jury should find it credible, given I'm going through all the circumstantial evidence that shows that this statement is incredible. She had no connection to this community. She had no car. She just moved here. She's not familiar with the area. There'd be no reason for her to drive MARTA in what would take 1 to 2 hours, as the testimony has established, from the place where she's working and stripping to sleep at night with her child when there are shelters available, when there are more reasonable alternatives. I mean, this is just an absolutely ridiculous story. We don't think it's going to be credible to the jury. You combine that with the fact that you have someone that lived across the street, that was familiar with the wooded area, and saw this very strange thing happen at least a month or more before William was found, where a car pulled into that cemetery in the middle of the night when it was dark.
Exactly, Mel.
Got out of that car and then quickly got back in and drove off at a fast pace. You have plenty of circumstantial evidence that not only is Ms. Black's story not believable, but to support the idea that this body was dumped at that location, combined with the fact that you have a 6-year-old body, 6-year-old bodies in a secluded area of the woods.
Let me ask you this, do you agree that the argument that it requires some affirmative act?
I think leaving the body there is an affirmative act.
Whether he died there or he died somewhere else and she put it.
Absolutely, Your Honor. That is an act. Leaving a 6-year-old's dead body in the woods is an act that hindered law enforcement from investigating this murder in a timely fashion and from discovering who William was and the fact that he had died. And so we think you should deny the count on the concealing the death for that reason. Additionally, the lying could have occurred to Ava within 3 days. We don't believe William made it very long in Atlanta at all, Your Honor. You heard that he was wearing the clothes that Ava saw him leaving, that he had been decomposing for 3 to 6 months. He was withdrawn from school on December the 1st of 1998 and found February the 26th of 1999. There's about one person in Atlanta who has come forward mentioning they've seen this child or have met this child or had anything.
Waterboard.
So
Waterboard.
died very, very quickly upon getting here. So he lied she lied to Ava about his whereabouts, wasn't able to put him on the phone. And additionally, there are special instructions about venue that the jury can find the crime occurred in any location in which it reasonably could have occurred. So we believe you should deny the motion for directed verdict on the concealing the death count. I'll just work my way backwards, Your Honor. As to the aggravated assault, all the medical professionals testified that a traumatic injury prior to death could not be ruled out. It is untrue, as stated by the defense, that any of them said that it was most likely one thing or the other, that it was most likely scavenging activity. That simply was not testified to, not by Dr. Gallup, not by Dr. Tice, not by anyone. They said they could not say which it was, and that it could have even been a combination of traumatic injury and scavenging, that a traumatic injury could draw animal activity and make animal activity more likely, and both could be present. You combine that with the fact that there's evidence that Teresa was previously physical with this child, that she had punched him previously, she had thrown him previously, that his body was concealed in the manner that it was dumped in the woods, hiding his death, that absolutely there is evidence that a fact finder could decide that Teresa Black assaulted this child and hid him for that reason. It is only appropriate to grant a motion for directed verdict, Your Honor, when there is no conflict of the evidence.
No, the waterboarding would just be the fun of it.
And inferences demand a verdict.
Strictly for the fun.
And that's just not true with an aggravated assault count. So we ask that you deny the defense's motion and allow the count to go to a fact finder. As for the cruelty for administering the drugs in count 4, Your Honor, which is the basis of the cruelty as well as the felony murder count based thereon in count 3, you've heard that the
great job, friends.
It's not uncommon for parents to use sleep-inducing drugs as babysitters. That this child had those types of drugs in his system, and that the symptoms he was having just prior to his death, when his mother said she knew there was something wrong with him, were consistent with a toxic exposure to those kinds of drugs. You combine that with the circumstantial evidence that Ms. Black was working as a dancer and sex worker, that she was not allowed to bring her child into the club, and there's certainly circumstantial evidence, and this count should go to a fact finder.
So am I understanding she's saying that she would go do these kind of activities and use those things as a babysitter? Am I understanding this right?
And then finally, counts 1 and 2, the cruelty to children for not seeking medical treatment. Again, the drugs were in his system. The symptoms are consistent with a toxic exposure. Ms. Black admitted that she knew something was wrong with him and that she did not take him to the doctor. And then again, you combine that with the circumstances of concealing his body.
I agree,
Dan.
Dan.
Living at the time, the work she was doing at the time.
Strictly recreational.
Again, there's absolutely a conflict in the evidence and enough circumstantial evidence to support a jury's verdict on these counts. So we ask that you deny the defense's motion as to counts 1 and 2 as well, Your Honor.
Thank you. Anything else?
Your Honor, I do want to go back to the concealing of it. I would ask if the state can produce any case law saying that it's sufficient evidence where someone leaves the body where the body passed away in a secluded area.
Brian Laundrie?
Some that I haven't seen find, but I haven't found any. And I think this makes it, this is a big issue that we're about to experience if this does survive a directed verdict.
Oh, boy.
She's indicted for leaving. And that can be interpreted 2 different ways, as we've discussed. One of them, I don't believe is backed up by law that that's legally sufficient. So I do.
Was this ever addressed in a demur?
Well, it's not technically a demur, I think, because it could be interpreted as dumping the body.
Look at the look on her face.
The court needs to limit what is a violation of the statute and limit it that way.
I hear you, but I have a hard time following that.
Verbal diarrhea.
Dead child in the woods to deteriorate is not, I don't understand how that would not be concealing the death.
Your Honor,
Yeah.
I think the difference is, and there's a couple of prongs here that I think the court and the state is focusing on. The fact that it people have been hindered from finding the body is one element, but it's just one. It's an act, it's concealing, which does hinder the discovery.
Well, there was some, you know, and if she dumped the body there was some evidence from which a jury can draw that conclusion. Then
No,
that would satisfy
me either.
your argument of the act. I mean, it's up to a jury to decide what happened. So I don't know, but I mean, there is some evidence that that the jury could find that she dumped the body there. So that would satisfy that issue. And if they don't find that.
Yeah,
it's up to
all
them,
the
fact
little
finders.
things that they
I
tried
do think
to,
there is, however, even if it's circumstantial, there's some evidence from which all of
I,
these.
yeah, that's
charges
exactly what I'm trying to
jury,
say,
so I
Dan.
deny all motions for directed verdict.
Well said.
All right, Ms. Black, I need
Yeah.
to advise you of your rights on the record. Do you understand that you have a right to testify in your own defense of this case, if you would like?
Yes, ma'am.
Do you also understand that you have the absolute right to not say a word? And if you decide you do not want to testify, I will instruct the jury that they cannot hold that against you in any fashion in their deliberations. You understand that?
Yes.
If you decide to testify, you will be subject to cross-examination by the state, just like any other witness. You understand that? And you have the right to consult with your attorneys and seek their guidance and counsel about whether they think it's in your best interest to testify or not. But that ultimately the decision has to be yours and yours alone. Do you understand that?
Yes, ma'am.
Have you had enough time to talk with your attorneys about whether or not you'd like to testify in this case?
Yes, I have.
Okay, and what would you like to do?
I would not like to testify.
Okay, then I will instruct the jury that.
That's
they
a
are
big
not to hold that
surprise.
Against you in any fashion.
Yes.
Okay. All right, you still have one witness?
I do, Your Honor, a medical examiner.
Okay.
Sure.
All right, so what, I'm gonna take a 5-minute break and then we'll come back and get that expert done and then we'll break for lunch after.
Okay, we'll just zip through this. I haven't, Dandy.
You're ready to
Nope.
proceed? You call your first witness.
Judge, defense calls Dr. Jane Turner.
Okay.
Raise your right hand. You swear or affirm the testimony to the court to be the truth, the whole truth, nothing but the truth, so help you God.
I do.
State and spell your name for the court.
My name is Dr. Jane Turner, Janeturner.
Good morning, Dr. Turner.
Good morning.
Because you are encased, it's really important you talk into the microphone so everybody hears you, okay?
Thank you.
Thank you. Could you please introduce yourself to the jury?
My name is Dr. Jane Turner. I'm a forensic pathologist
And Dr. Turner, what city do you live in?
in St. Louis, Missouri.
When you say a forensic pathologist, have you also worked as a medical examiner?
Yes,
Are those terms used synonymously sometimes?
yes.
Can you tell the jury a little bit about your educational background?
I received all of my degrees from St. Louis University. I'm a native St. Louisan. So I have a BA in biology from St. Louis University, a PhD in physiology from St. Louis University, and physiology is the study of how the body works.
Good uni, I've
And I
heard.
have a medical degree from St. Louis University.
Where did you begin working after medical school?
After medical school, I started my training in anatomic and clinical pathology at the University of Oklahoma Health Sciences Center. I then later came back to St. Louis and completed that training at St. John's Mercy Medical Center in Creve Coeur, Missouri.
What other types of work have you done in your career?
Well, I did additional training in forensic pathology, fellowship training at St. Louis University. And once I completed that training, I was hired by St. Louis University as faculty to work at the City of St. Louis Medical Examiner's Office.
And when was that? Do you recall?
That was 1999 or 2000.
Okay. What have you done since then?
I worked for 18 years at St. Louis University as a professor. I rose through the ranks to become a full professor. And when I was working for St. Louis University, I worked primarily at the City of St. Louis Medical Examiner's Office, performing medical legal autopsies and testifying in court as needed. I also was teaching medical students and residents, and I became the program director for the forensic pathology training program. So I did that for a number of years. And I also took on the directorship of the autopsy service at the hospital. So at the medical examiner's office, I was performing medical legal autopsies. And then at St. Louis University Hospital, I was performing and overseeing the performance of hospital autopsies, which are not medical legal or not forensic cases.
How many total years have you worked as a medical examiner?
Well, so as a medical examiner in the City of St. Louis for 18 years, and then I've practiced as a forensic pathologist after that. So a total of almost 25 years as a forensic pathologist.
How many autopsies have you performed?
Well over 5,000.
Have you ever been published in any medical journals before?
I have.
Do you have any special certifications?
I have certifications from the American Board of Pathology in anatomic and clinical pathology and in forensic pathology.
Do you have any special certifications relating to child death pathology?
Yes, the state of Missouri has conferred upon me a certified child forensic pathologist or pediatric forensic pathologist.
And what does that give you the ability to do in the state of Missouri?
That's a big mistake, eh? Wow.
They've given me permission to perform medical legal autopsies in pediatric cases.
Have you performed autopsies in pediatric cases before?
I have.
Do you know how many times?
My best estimate is around 400, maybe more.
Have you ever testified as an expert before?
I have.
About how many times?
In a trial setting, over 200 times.
How many times have you testified as an expert for the prosecution?
About 150 times.
Okay, so for the defense, 50 or around there? Is that
Around 40. I've testified in civil cases as well.
Okay. Now today you are testifying for the defense.
It's a bad mistake,
Yes.
Andy. Holy.
And are you being paid for the time that you've spent reviewing this case and for testifying?
Yes.
Do you own your own firm or consulting firm now?
I do.
When did you start that?
I started that a few years after I completed my training in forensic pathology. I was approached by attorneys at some point after I completed my training asking me to review cases for them.
So most of the time that you've been practicing as a forensic pathologist, you've also been consulting.
Yeah, that's a pretty big mistake, Andy. Like, what the hell? I could see there being a big stink being made over that now, because that's just something that they should have handled. It is. I agree, James. Shocking mistake. Yeah. I mean, they should be doing better than that.
Consulting.
Yes.
Okay.
Wow.
Do you know how many states you have been testified? I'm sorry. Do you know how many states you have testified in as an expert?
I'd probably be able to.
I would estimate around 10, maybe 12.
Your Honor, at this time, defense would tender Dr. Jane Turner as an expert in forensic pathology.
Any objection?
No, Your Honor.
All right, she will testify as an expert in forensic pathology.
Dr. Turner, have you ever worked on a case as a forensic pathologist involving decomposed remains?
Yes.
What type of challenges does that create when you're working with decomposed remains?
Well, the degree of decomposition can obscure findings. The degree of decomposition can interfere with the ability to perform toxicology testing with results that you can correlate with cause of death. Decomposition can interfere with forensic.
I'm serious. Like, this just has Letitia Stout all over it. I mean, it's another nightmare. The young kids and such disrespect, and it doesn't seem like any remorse. These are some of the hardest cases to even look at.
Pathologist's ability to determine cause and manner of death.
Did you review any materials in this case? The
Yes.
case we're here for?
Yes.
Do you recall what all materials you reviewed?
I reviewed quite a few materials. Certainly the autopsy report, scene photographs, police investigative reports. There was DNA testing. There was an effort to identify the clothing, who purchased the clothing on the child, that was found on the child. I reviewed anthropology reports, toxicology report, and autopsy photographs.
I'd like to begin with the toxicology portion of this case. You said you did review toxicology reports in relation to this case?
Yes.
Do you have an opinion on the findings?
Yes.
Okay, what's your opinion?
That the toxicology testing of the decomposing skeletal muscle found the presence of Tylenol and Benadryl.
Are you able to tell anything about what the dosages would be for this child for these two medications?
No.
Is it fair to say these could represent a toxic dose of the drugs?
That's possible.
Could these levels represent a therapeutic dose?
Yes, that's possible as well.
And could you explain to the jury, what does a therapeutic dose mean?
A therapeutic dose means the target range of blood concentration for the drug that has the desired effect. But we're not looking at blood in this case, we're looking at skeletal muscle.
And because we're looking at skeletal muscles, is that the reason why you can't determine any dosages?
Yes.
With a therapeutic dose, if William was given a therapeutic dose, would he have experienced any pain from these drugs?
No.
Could these levels represent a trace
dose? And?
They could represent any range of dose or any range of blood concentration at the time of his death. Testing skeletal muscle is useful only for telling you that the drug was present, not what the drug concentration was at the time of death.
Okay. Now on a if this was a trace dose that William received, you would not expect any pain to be caused by that as well, correct?
Correct.
I'd like to talk a little bit about the anthropology.
Well, what's the
portion.
point
You also reviewed some
to that questioning?
reports from anthropologists, is that right?
Yes.
Okay. Right. Did you review anything in the case materials concerning a fracture to the right zygomatic arch?
Yes.
Okay. Do you have an opinion about this fracture?
Yes.
All right. Could you please share with the jury ultimately
Yeah,
your opinion?
you're exactly right, James. It can tell you a lot.
The anthropologists that reviewed the skeletal remains indicated that there was evidence of animal scavenging. The absence of a portion of the zygomatic arch is in keeping with that observation.
Can you explain a little bit to the jury how a fracture like this would be caused by animal scavenging?
It can be caused by animal scavenging from gnawing. It could be caused from animal scavenging from the animals moving the skull and breaking that bone. That bone is a small, not very thick bone.
I don't really understand that. I don't think
And what
she's
evidence in this case
proving any.
supports the idea that this fracture was caused by animal scavenging?
Some of the other bones demonstrate changes that are in keeping with animal scavenging or animal gnawing on the bones.
Can you describe those other, the other damaged bones that inform your opinion?
One example is the mandible or the jaw. The ends of the mandible are rough and irregular, in keeping with an animal having gnawed on the two sides of the mandible.
Dr. Turner, I'm going to show you what's
That's
already
way
been marked,
different than a
what's
great big
already entered
fracture in a
as State's
skull.
Exhibit 65. We're going to go to
I agree. I agree with you guys.
21. I'm sorry, figure 20. Can you tell the jury what we're looking at in figure 20?
It's unreal.
We're looking at
Yes.
the mandible, William's mandible, at one end of the mandible. So the end we're looking at is,
I agree.
the right
Like
side at the joint. But we're looking at the bone after it has been altered through the process of restoration.
What do you mean by altered?
Someone has applied material to replace the missing part of the end of the bone.
Now, when you say that, are you talking about the dark part on the end here?
The dark part, also the cottony material.
I'm going to show you next.
I mean, you can always find a witness. It's like
State's
just really,
Exhibit 46.
how good are they at their
What are we
jobs?
looking at here?
This is a photograph that was taken of the mandible at the scene, and we're looking at the irregular ends of the mandible, the right on the left side of the screen, and the left end at the top left part of the screen. And you can see that the ends are not symmetrical. They should be the same length and shape and appearance, and they are not.
That's still different
Is
than
it typical to
a crack on a
does the
skull.
mandible typically have these rough edges
No,
on the ends?
no.
Now, you said that this
This
was the pieces on the end were added in restoration.
Making a
Are
lick
you
of
aware
difference.
of why that would have happened in this
To
case?
me.
My understanding is that it was part of the process in trying to identify William in reconstructing his facial appearance.
I'm going to show you next the same exhibit, State 65, figure 21.
Yeah, I'm having a hard time kind of understanding what the purpose is of this because what I've heard so far hasn't convinced me that that crack on that skull was caused by animals. It's two different types of injuries, in my humble opinion.
Is this more of the reconstruction material that you're referencing?
Yes,
From your view between this picture and the other, I'm sorry, the scene photograph, is some of that damage that you saw, that you mentioned in the scene photograph, covered up here by the clay or cotton or whatever that is?
yes.
Can you still see other damage that you believe is indicative of animal scavenging?
Well, the top surface appears rough and irregular, which would not be typical of a bone surface.
I'm going to go down to figure 22. Is this that same bone we were already talking about?
Yes.
And do you note any additional damage to the bone we haven't talked about already?
No.
Next, I'm going to jump to figure 3 of the same exhibit. Is there anything significant in this picture?
In this picture, we're looking at the left side of William's skull with the mandible in place. And you can appreciate at the joint area at the end of the left mandible that there's some of that black material as part of the restoration process.
And is it your understanding through your review of this that parts of the bone were missing there and that's why something had to be added to restore it?
Yes.
Going back a little ways. What are we looking at in this photograph?
We're looking at the right side of the skull with the mandible and with the restorations apparent in black and I'm not sure about this other discoloration, this yellowish discoloration, if that's also part of the restoration.
Now, does this photograph show the break in the zygomatic arch?
Yes, it does.
To your knowledge, was that piece of bone ever recovered?
No, it was not.
How would you explain that in your experience?
It could have been digested by a scavenging animal.
Is there anything about the zygomatic arch that makes it prone to damage from animal scavenging?
Well, with animal scavenging, the animals, and I've experienced with rats, having done this, and in some cases I've had where people died in rat-infested homes, rats will gnaw at the nose and the cheek and the chin. Anything that's protruding, they'll gnaw at it.
Are you aware that Dr. Meredith Tice found that there was not scoring or scraping or furrowing on the zygomatic arch? Are you aware of that opinion?
Yes.
How do you justify that opinion with yours that this is caused by animal scavenging?
Well, again, if either it was from gnawing activity, which Dr. Tice is of the opinion that there's no evidence of that for the zygomatic arch, there is elsewhere on the skull, or that piece of bone was broken off due to the activity of animal scavenging.
Yeah, like what are we talking? Mice?
Dr. Turner,
or
in your opinion, is there
height?
anything in this case that suggests or leads you to believe this injury was caused before death?
there's no supporting evidence for that.
I'd like to talk to you next a little bit about the time of death. Okay. Do you have any opinion on when William died or how long William was in the woods?
No, I don't know.
Could it be less than a month?
Yeah,
Yes, that's possible.
What type of
they can, James.
things
Absolutely.
affect decomposition time?
There are numerous variables. So the mass that you're dealing with, so the size of the individual, exposure to sunlight, exposure to heat or cold, dampness, and then on top of decomposition, you have insect activity and animal scavenging
agree, Dan.
activity.
And animal or insect scavenging activity could speed up the process of decomposition.
Yes,
Are there any pathological issues or causes of death that could speed up potential decomposition?
someone who dies with an infection, sepsis, fever, so an elevated body temperature can accelerate the initial phases of decomposition.
I'd like to start next talking about some.
Did that
possible
make
causes
sense?
of death,
Someone running
for
a
William.
fever who was not alive.
Have you formed opinions on other
Did I hear that right?
possible causes of death for William?
Well, my opinion is that the cause of death is undetermined or unknown, but certainly there are numerous possible causes of death for a child and a child living in this environment.
Could you tell the jury a little bit about what exposure means as far as a cause of death?
In this case, the exposure would be hypothermia or cold exposure, so dying from exposure to cold, so freezing to death.
Could that be a
Okay,
potential
thanks,
cause of
Maxie.
death in this case?
Yes.
You mentioned sepsis earlier. Could you tell us a little bit about what sepsis is?
Sepsis is a potentially fatal illness, and it is the body's inappropriate response to the presence of infection. So it's not the infection itself that can cause death. It's the body's response to that infection. And what sepsis does is it causes loss of regulation of
Barking
normal
mad.
physiologic processes. So it can cause the heart to function poorly. It can cause the lungs to not properly aerate blood. It can cause the liver to shut down, the kidneys to shut down. It can cause the brain to shut down.
And what could be a potential cause of sepsis?
Well, we're familiar with
Yeah. Well said, Mel.
that type of that type of response the body has to COVID infection, but we're not talking about COVID from 1999. But the more common causes of sepsis
Okay.
include pneumonia and urinary tract infections. Viruses can cause sepsis as well.
Doctors
And
leaving
is
dirty
sepsis
tools in
a
your body.
possible cause of death in this case?
Sepsis.
Certainly.
And what type of symptoms would we see from that?
Malaise, lethargy, just not feeling right.
Would there be any stomach issues, gastrointestinal issues? Excuse me.
There may be, it just depends on the organism and the body's response to that organism.
Right. And you mentioned pneumonia earlier. Is pneumonia a potential cause of death in this case?
Yes.
Any symptoms of pneumonia?
Pneumonia can cause fever, again, malaise, lethargy, cough, can cause vomiting, can cause irregular breathing.
Good question, Mel.
Could food poisoning be a potential cause of death?
Yes,
Could it be a potential cause of death in this case?
yes.
And what would the symptoms of that be? I think maybe we know that one, but what could the symptoms be?
So why don't they just say
You can
anything?
have a variety
Because
of
they're just
symptoms. You
throwing
don't
like
necessarily have
crap
all
at the
of them
wall
at
and
the
hope
same
it's
time. You
fixed.
can have abdominal cramping, diarrhea, vomiting, nausea.
Dr. Turner, is it possible that the symptoms William was experiencing be something that was non-fatal,
Yes,
like a cold or a virus? Is that possible?
yes,
And is it possible that he also had something else, perhaps unforeseen,
Yes,
that did cause
exactly,
him to die?
James. Well
Yes.
said. Because
Would it be
that's all it
would
is
a
speculation.
seizure, an undiagnosed seizure disorder, be a potential cause of death?
yes.
Can you walk us through a little bit about what that's like, or how that
Get a
causes
bolt of
death,
lightning.
or
Yes. Get a
obviously
meteorite
to parents'
dropping
minds?
on his.
Well,
Yes. Oh my.
people who die of seizures, and children as well, often have seizures in their sleep. And it's particularly dangerous and
Oh, good
potentially
question.
fatal if they have a seizure in their sleep while they're in the prone position or while they're lying on their stomach. And in some individuals, the first seizure they have is also the last seizure they have.
And that's because they pass away, right?
Yes,
Would a parent see signs or symptoms of this coming, a seizure disorder?
no,
Is there a risk a medical professional would not see this coming?
that's correct.
So literally, like I said, they're just throwing crap at the wall and seeing if it sticks because literally all she's basically saying is anything is possible. That's all she said. They didn't explain from where I'm sitting anyways, anything that would have caused these injuries to be caused by animals. Some of the smaller ones, yeah, but not from my understanding of the damage. I've never heard of animals, maybe a bear, but it's honestly, it's infuriating because it's just a whole bunch of nothing. I don't even know what to say about her. No,
What about undiagnosed diabetes?
no.
Could that be a potential cause in this case?
Oh, it could.
Yes.
You
Can
see? Oh my
educate us a little bit about that,
God.
please?
Children can develop,
That's
or
what
can
I'm
have
thinking.
diabetes. They can,
Like,
there's an entity known as
I
juvenile
don't even know what to say
diabetes.
about this. Like, what?
The signs and symptoms may
What?
not be apparent until there's an illness, and that illness triggering what's known as diabetic ketoacidosis, which is a severe metabolic disorder.
And can that cause death?
Yes.
Yeah, for
Are there any
sure. But
other
I
heart
think what they're
conditions,
saying
brain
is
conditions,
responsible is
abnormalities
large.
that could be a potential cause of death here?
Certainly, you can have a viral infection of the heart known as viral myocarditis that can cause death. You can have an abnormality of the muscle cells of the heart that cause congestive heart failure or a fatal arrhythmia or fatal irregular beating of the heart.
So what is the
Could
likelihood of
electrolyte
all this stuff?
disturbances be a cause of death in this case?
Yes.
How would that work?
Oh my word.
Well, if there's severe vomiting and diarrhea, that can deplete the body of its normal balance of electrolytes, sodium, potassium, chloride, and that can trigger heart arrhythmia or fatal arrhythmia of the heart resulting in death.
Are you aware of any liver disorders, genetic liver disorders that would make a person more prone to toxicity from acetaminophen?
Oh my word.
Would meningitis potentially be a cause of death?
Certainly, yes.
How does that work?
How does that work?
Well, you can have viral meningitis or bacterial meningitis, and depending on how virulent
What's the likelihood of this stuff?
organism
Come
is,
on.
the death can be rapid and can occur during sleep.
All right, I've asked you about a lot. Dr. Turner, are there any others that are coming to your mind that could be potential causes of death here?
Everything,
Symptoms.
if you want to play that game.
There can be gastrointestinal catastrophes,
There we go.
the bowel twisting on itself and cutting off blood supply.
Oh,
to the
come
bowel,
on
and that can
now.
cause sudden death.
And how much are you
rapid
being
death,
paid,
It
doctor?
can allow bacteria to get into the bloodstream and cause sepsis. It can also cause peritonitis or infection of the abdominal cavity.
Is there anything?
Oh, this is hard to
in the
sit here
record
and
of this
listen to, isn't it?
case
It's
or
painful.
anything from the symptoms described in this case that can aid you, a forensic pathologist, in determining a cause of death?
The symptoms, as I understand it, are pretty generic, non-specific. So there are any number of potential causes of death.
Are there several things that this could be for a child to exhibit those symptoms where a parent would not need to take a child in for medical treatment?
Well, I've seen that where a child has nausea and vomiting and dies at
Upset
home
stomach,
because the parent
diarrhea.
can't see
Oh.
inside the body and know how severe the illness is.
All right. In your review of this case, did you note anything else significant about the other conditions of the remains? Was there anything about the conditions of the remains that you noted to be significant?
Good question, Mel.
Well, I noted that there was still maggot activity as photographed at the scene. I also noted that Doctors Terry and Gowit described William's toenails being trim and neat. The tufts of hair that were recovered at the scene.
Yes,
weren't
we do.
matted. His teeth were intact. He didn't have any
One of my
cavities,
personal
according to
favorites.
Doctors Gowit and Terry. He also didn't have any fillings or restorations of his teeth.
I believe you mentioned earlier you've worked child death autopsies before, right?
Yes.
Have you had contact with maybe children's parents after autopsies are performed?
Not very often, no. It's if I have, it's been by phone. Most of the contact between parents and the office were through the investigator in the office.
In your opinion, when you are making opinions about the autopsies you perform, does the way parents react to their death, to the death
It's
of their
just
child,
So
inform
much
your opinion?
speculation, like,
No,
Why is that?
because there's a spectrum of reactions. People come from different backgrounds and family environments where they deal with stress in different ways. It's not, to take that into account is not scientific. It introduces an element of bias.
because everything she just spouted was
Dr. Turner, from your
scientific.
review of this case, is there any evidence
Oh my
to support a conclusion
God.
that William died from an overdose of acetaminophen or diphenhydramine?
No.
Is there any evidence to support a conclusion that the zygomatic fracture or any other damage to William's skeleton happened while William was alive?
No.
Is there any evidence to support a conclusion that the manner of death in this case was homicide?
No.
Thank you.
All right, cross.
Oh, you're welcome. You're welcome. I don't like this. I don't like this at all. 1000% speculation stated as fact. Personal pet peeve. And it's allowed because, you know, it's the defense.
Now, you would agree with Dr. Gallant and Dr. Tice that you cannot determine a cause of death in this case.
I do agree with that.
And you would agree that you cannot
Thank you.
determine the manner of death in this case.
That's correct.
Thank you.
Now, a medical examiner's determination of manner of death is different from the jury's determination. Isn't that correct?
I agree.
A medical examiner is looking at the medical aspects of the case and preparing an autopsy report.
Yes.
Correct?
Yes,
You are not making a legal decision, correct?
that's correct.
It's the jury's job to make a legal decision about the manner of death, correct?
Yes.
Exactly now.
Let's discuss the skull fracture. You can't rule out traumatic injury while the child was alive, can you?
No,
You agree with Dr. Gallant,
Boom.
correct?
I'm not sure what you're referencing.
That you can't rule out traumatic injury prior to death.
I can't rule it out, but the
Uh-huh.
appearance of the skull with the other evidence of animal scavenging is in keeping with postmortem damage to the skull.
So the answer to my question is yes, you can't rule it out.
I can't rule it out.
And you can't rule out that there may have been traumatic injury combined with animal scavenging. Isn't that correct?
Boom.
That's correct.
So you agree with Dr. Gallant?
Again, I don't know what Dr. Gallant said.
You didn't read his report?
I read his report. I don't remember him saying that he can't rule out traumatic injury.
Did he commit to how the injury was occurred?
No, he did not.
So you agree with Dr. Gallant? You can't say how the injury occurred.
I can say that more likely than not, that the damage to the skull was from postmortem animal scavenging.
But you can't rule out that a traumatic injury occurred prior to death, correct?
That's correct.
Just like Dr. Gallant
Exactly.
and just like the anthropologist in this case, Dr. Tice.
That's correct.
Now, I want to
Why
talk
is
about the
why is she so defensive?
symptoms. What kind of symptoms would a child had if they weren't getting enough to eat and drink?
They would have lethargy, lack of energy.
And how long would it take for a child to die from not getting enough to eat and drink if there are no other complications?
Well, it depends on the severity of the malnutrition and what their base state of health was, but children die of malnutrition due to infection. So it's infection exacerbates the condition, and infection can occur at any time. So a child can die within a week of malnutrition or days and months.
You'd agree that typically it takes a long time to starve a child in the absence of other contributing factors, just taking away food and water. Correct?
Typically, yes, typically.
And if a child was deprived of enough food and water that it actually caused their death, you'd agree that you would likely see skeletal changes, correct?
You would see skeletal changes if the malnutrition was of a long duration.
She's trying to dance around things.
Food poisoning. What are some of the symptoms you see with food poisoning?
So as I testified to earlier.
Oh, that one.
Can abdominal cramping, nausea, vomiting, diarrhea.
And typically, food poisoning corrects itself in most people. Isn't that right?
Yes,
Most people recover from food poisoning in a day or two without the need of any trips to the hospital or visits to the doctor.
that's true.
Yes.
And when you do need to go to the doctor, it's often because you're vomiting and you have so much diarrhea that you're becoming very dehydrated.
That's correct.
You didn't hear any evidence in the case about this child vomiting or having diarrhea, did you?
I have not.
Not even a little bit.
I have no information on that.
Let's talk about the acetaminophen and diphenhydramine. If a dead child has those drugs present in their body, and their parent has given a statement that they knew something was wrong with them, that they didn't want to talk, that they didn't want to get up, they weren't throwing up, they were lethargic, weak, tired, there's some gagging. Could that be consistent with being exposed to a toxic amount of either of those drugs?
The toxic effects of acetaminophen is nausea, vomiting, and then skin coloration change, jaundice, ultimately. With diphenhydramine, it's drowsiness, so not so much lethargy, but drowsiness and irritability.
So your testimony is that you're always going to see vomiting when you have a toxic exposure to acetaminophen.
No, not always. It's one of the symptoms.
Is it fair to say it can be a symptom?
Yes,
So these symptoms combined with the presence of the drug actually being in the body and having a dead child could be consistent with a toxic exposure to one or both of those drugs. Isn't that correct?
yes, I stated as such with Mr. Bozarth that the drugs could have been at a toxic level.
She's
but we
so
just don't know, and we can't
defensive.
know.
So it's not correct that the evidence is inconsistent with a toxic exposure.
That's correct.
I want to talk about the medicines at issue. Acetaminophen, diphenhydramine, said Tylenol and Benadryl. Is that correct?
Yes,
And Tylenol and Benadryl are often found in over-the-counter medications that induce sleep. Isn't that correct?
but Tylenol doesn't induce sleep, but Benadryl does.
And let me be clear, the two medications together, when they're put together in one over-the-counter medication, it's often in a medication that induces sleep.
Well, I just want to be clear that Tylenol has no contribution to inducing sleep. It's the ingredient that induces sleep is the Benadryl.
I understand. My question is, when you find these two drugs in a product together, that product is usually intended to induce sleep, correct?
Yes,
I'm showing you exhibit
Mel.
87 and 89. I'm sorry, 88. Do you recognize these exhibits?
yes.
What would 87 be?
Like, why is she defensive?
87
She's
is a liquid form of
mouse.
Tylenol with with Benadryl.
Tylenol PM.
Yes.
And if you would just leaf through, take a look at the uses, side effects, directions, warnings. You see the printout is from the distributor Tylenol's website, correct?
Yes.
Do those warnings, uses seem consistent with what you would expect for Tylenol PM?
Sure.
Your Honor, the state tenders 87 into evidence.
Any objections?
Objection.
It's admitted.
And then 88, does that appear to be an authentic package of Tylenol PM capsules?
Yes.
Your Honor, the state tenders 88 into.
Yeah, that's.
Any objection?
Oh. Oh, good night, James. Thanks for
Both
being here,
these,
friend. It was really good to see you.
Medicines, the capsules and the liquid, they're going to be found in the area of the pharmacy where you get sleep aids, correct?
Cold or sleep, yes.
In fact, there's actually a different section.
So this is just unreal
cold
dandy.
medications.
Yes.
These items are separate from those.
I don't know. We may shop at different pharmacies.
Oh my God.
Would
Look
it
at
surprise
this.
you? I went to 5 different pharmacies yesterday. I haven't finished my question.
Council's bringing up her experience.
All right, can you rephrase the question in a hypothetical?
I'm asking, would it surprise her based on my experience? There's no bar against that, Your Honor.
I think she's right. All right, overrule the objection.
But would it surprise you that I went to 5 different pharmacies and in every one, the PM medications were in a sleep-inducing section and the cold medicines were somewhere else?
No.
Let's talk about the Tylenol PM. I wasn't able to find a liquid form. I've got the printout for you there in 87. The active ingredients are what?
Acetaminophen and diphenhydramine.
And what are the doses or the amount in a dose for Tylenol PM in the liquid form?
Unreal.
This appears, so this isn't a pediatric bottle. So this is an adult dose of 1,000 milligrams of Tylenol and 50 milligrams of Benadryl.
And is it common in your experience for the sleep aid section to have medicine for children that induces sleepiness?
No.
And there's a reason for that, isn't there?
Children don't typically have sleep disturbances.
And it's not safe for children to take medication to induce sleep. Isn't that correct?
I don't know. That's outside my area of expertise.
But all these sleep-inducing medications are
Unreal.
made for adults.
Dandy.
Yes.
And what is the adult dose for acetaminophen
1,000 milligrams,
and diphenhydramine?
50 milligrams.
Tell the jury what the recommended uses are for Tylenol PM.
Pain reliever and nighttime sleep aid.
So you get this if you're in pain or you're having difficulty sleeping because of pain.
Yes.
Is there a liver warning?
Yes.
Is it in bold?
Yes.
What does it say?
Severe liver damage may occur if you take more than recommended, basically. And if you take it with other drugs containing Tylenol, or if you take the medication with alcohol.
And that's in an adult.
Yes.
What does it say about children?
This is not packaged for children.
But what does it say?
It doesn't say anything about children. It's not packaged for them.
It doesn't
Are you
say do
kidding me,
not
lady?
use in children under 12 years of age.
Whoa. She's not doing them any favors, let me tell you that. Like, she's offensive.
That is on a different page, but yes, it does say that.
And that warning is gonna be
Oh.
on the bottle that's sold in the
Different
store.
page.
Yes,
Does it have an overdose warning?
She's just, I don't like this woman. I don't like her at all.
yes,
Does it say to contact poison control right away?
yes,
That quick medical attention is critical?
yes,
And to not take more than directed?
correct.
Again, this is for adults.
Yes,
For children, it says do not use.
that's correct.
The capsules aren't gonna be any different, correct? They're gonna have the same medications, the same warnings.
Yes,
I truly can't get over why this woman is defensive. I know I'm being repetitive here, but there is why, if she's being honest, straight up, transparent, isn't the goal to find out what the hell
Showing you
happened?
Exhibit 89.
Or is it just to please the defense?
Recognize this exhibit?
yes,
Does it appear to be an authentic bottle of ZZ Quill?
yes.
Your Honor, the state tenders 89 in evidence.
Any objection?
Objection.
All right, submitted.
Now, this is the Vicks version of the same medication, correct?
Yes,
Has the same amount of acetaminophen.
yes,
Same amount of diphenhydramine.
yes,
And it has the same uses as the Tylenol PM
that's correct.
for pain and to induce sleep.
Yes,
It also has a liver warning in bold.
yes,
This one warns adults that liver damage can occur if you take more than 4 doses in a 24-hour period.
correct.
That's in adults.
Yes,
Says to keep out of reach of children. Do you see that?
yes,
And it says do not use in children under 12 years old.
correct.
I think you're right.
Showing you exhibit 90. Do you recognize this exhibit?
I'm not familiar with the brand, but it's another nighttime sleep aid.
Does it appear to be an authentic bottle of Equate nighttime sleep aid?
Yes,
Your Honor, the state tenders 90 into evidence.
Any objection?
Objection.
All right, 90 is admitted.
And the Equate nighttime sleep aid also has 1,000 milligrams of acetaminophen
yes,
and 50 milligrams of diphenhydramine.
yes,
She's not even looking.
Has the same uses of treating pain and inducing sleep.
yes,
See,
Has
not even
a
looking.
liver warning in bold.
yes,
Says that liver damage can occur if you take more than 4
Yep,
doses
me too,
in
Mel.
a 24-hour period.
yes,
And it says not to use in children under 12.
correct.
But she's not familiar with it.
These are all adult medications.
Yes,
They also do make children's formulas of medication. Isn't that correct?
yes,
Now, you don't get a lot of combined over-the-counter medications for children, as we've already discussed, where you have more than one active ingredient in the same product. They
That's
don't make a lot of those, correct?
that's correct.
That's because in cases involving children, you really want to individualize their treatment. Isn't that correct?
I'm not a pediatrician.
Here we go.
So you're
Oh
not
my
familiar with how
Oh, dandy, that's-
children are administered and prescribed drugs, common over-the-counter drugs?
No, I'm more familiar with the toxic effects.
That's so,
So you're familiar with the
heartbreaking.
toxic effects of over-the-counter drugs, but you don't have any training or knowledge of what would be prescribed to children?
I'm not a prescriber, I'm a forensic pathologist.
You're aware that children have different metabolisms than adults?
Yes,
They break drugs down differently?
I don't like that this woman's so
I'm not sure what you
defensive.
mean by that.
That
Like,
children's
I don't
bodies
understand the reason
break
for it.
drugs
Isn't she
down
supposed to
differently
be
than
neutral?
adults' metabolism?
Well, that's a very vague statement. I mean, are you saying that children break down the drugs into different metabolites than adults do, or?
That they break them down differently? Is
Well,
that not a true statement?
it's a very vague statement. I don't know how to answer to a vague statement. I'm not sure you know what you mean by that.
Is it an untrue statement that children metabolize drugs differently than adults?
Are you talking about how quickly they metabolize them, or
In
are
any
you
scenario.
Just,
I'm sorry?
In any scenario.
Well, they don't break down the drugs into different metabolites. That's not true.
I didn't ask you if they break them down into different metabolites.
I don't think you know what you're asking me.
oh, she's a
asking you
snotty
if they
little
different
frickin'
metabolisms
woman.
than adults.
Are you talking about metabolic rate?
Didn't you just agree that children have different metabolisms than adults?
No, I didn't. You've
That's
asked me
the
that,
first
and I've
one.
asked you to clarify that.
Well, how about this?
Oh yeah, exactly,
Dosage
Maxie.
of all drugs in kids going to be less.
She's not doing the defense any favors.
That's correct.
And that's because their livers are still maturing.
That's one reason, yes.
And a child could get sick on an adult dose.
Yes,
So you want to minimize the potential side effects for children.
correct.
And that's why you have children's formulas of medications like Benadryl and Tylenol.
That's correct.
I'm blown away. I really am. Like, I don't understand why she feels the need to be so defensive. It's all over her face. She's even flushed. Yeah, exactly, Mel. She thinks
Showing
she's
me
all that.
exhibit 91, do you recognize this exhibit?
Yes,
And does that appear
Yeah.
to be an authentic bottle of children's Tylenol?
yes.
Your Honor, the state tenders 91 into evidence.
Any objection?
Objection.
All right, so then,
And 92, do you recognize this exhibit?
Yes,
Does that appear to be an authentic bottle of children's Benadryl?
yes.
Your Honor, the state tenders 92 into evidence.
any objection?
Objection.
All right, submitted.
Now, children's Benadryl, it does not contain acetaminophen. Isn't that correct?
That's correct.
It has 12.5 milligrams of diphenhydramine, correct?
Oh, she's gonna look this time.
Yes,
That would be a quarter of what's in one dose of the adult medications.
that's correct.
And the uses, tell the jury what you use children's Benadryl for.
For runny nose, sneezing, itchy, watery eyes, hay fever, upper respiratory allergies, and itching of the nose or throat.
And it says, do not use to make a child sleepy, doesn't it?
I love how the lawyer's like all calm and this woman's just getting zipped right
That's
up.
correct.
The children's Tylenol, that does not contain diphenhydramine, correct?
That's correct.
And how much acetaminophen does the children's formula have?
160 milligrams.
That is about a sixth of what's in an adult, one dose of an adult formula. Isn't that correct?
Yes.
What are the uses for children's Tylenol?
My senior eyes are being challenged by the fine print here. Let me see. Sore throat, headache, cough.
Good question,
Fever.
Maxie.
Sneezing and running nose, and minor aches and pains.
And what is the maximum dose of children's Tylenol in a 24-hour period?
Yeah, great question. Wonder how long they have to look for some of these wing nuts. Personal opinion.
You might need to direct me to the packaging here. I don't see it.
You see somewhere where it says the maximum is 5 doses?
That's a good question, Mel.
Thank you. Thank you.
Oh, being nice now.
Wow, that's really small.
I think she said that's really small.
Yes, it does say
What
that.
about the
I
writing?
was like 5 or 3, 5 or 3.
Do not give more than 5 doses in a 24-hour.
That's correct.
And 5 doses is still less than a single adult dose.
Yes.
Is that correct? Children's
I had
Tylenol
children's
also has
Tylenol and
some
stuff like that when I was bringing up my
Yes.
son.
And as a warning, do not use to make a child sleep.
Oh yes, look again. It's not that hard. I can't see it again.
That's correct.
Also has an overdose warning.
Yes.
How many cases have you worked involving the remains of unidentified children?
Very few.
How many?
I told you yesterday, probably about 3.
And you could also get
That's
like the
because
Tylenol in a
children are
where you use like a
identified
syringe
quickly.
and you just measure it out a little bit.
How many cases have you worked where you were examining the bodies of children that were abandoned somewhere?
Well, that would be the same.
The same 3?
Yes.
And one of those
Oh,
cases
3.
was a child that died while they were in the care of a friend of the father's, correct?
Yes.
The friend abandoned the child's body in the woods.
Yes.
The child was found and an autopsy was performed,
Yes.
and the child had a ruptured intestine.
Yes, from a defect in the intestinal tract. Yes.
Luckily, you found this, well, not you, but law enforcement found this child, or family did, before the child severely decomposed.
Correct.
You had the intestines and bodily organs to examine.
That's correct.
Abuse was suspected in this case, correct?
Yes.
And the friend of the father was charged with the child's death.
Yes.
And that case is still pending.
Yes.
One of the other cases was a young woman who claimed she didn't know she was pregnant, correct?
Yes.
She said that she unexpectedly gave birth to a stillborn child and disposed of the body.
Yes.
And that woman was charged.
Yes.
And that woman was convicted.
Yes.
I'm going to object to this. We are bringing in other cases to compare them to ours.
What's the relevance of this, Ms. Holler?
The fact that the only 2 cases that prior to this one that this doctor conduct on
Well, that in and of itself is fine, but getting into the results of those cases is irrelevant. So,
Making the point that people have.
You can see him going in the back.
I'm gonna move on. I'm gonna instruct the jury. Do you want me to give them an instruction? Not, please don't, yeah, that's, whether or not, what's happened in other cases is irrelevant for purposes of this case, and you're not to consider that.
Your Honor, respectfully, I disagree that a medical examiner whose whole job is to investigate and determine cause and manner of death in connection with
Yes.
prosecutions has only had 2 cases of abandoned bodies, and both were connected to
fine.
criminal prosecutions?
Whether or not they were connected, the 2 cases is fine, but whether or not they were connected to criminal prosecution or what the results were of those cases is irrelevant and not admissible. I'm going to instruct the jury to disregard it and ask counsel to move on.
Getting tough. Honorable Stacy K. Hedrick.
You also indicated yesterday that you had never performed an autopsy of a child who died of food poisoning. Is that correct?
To my knowledge, yes.
To my knowledge. Could have done it and not remembered.
On direct, you indicated that it's difficult working with decomposed remains.
It can be, yes.
And it presents challenges to performing an autopsy.
To performing an autopsy and analyzing the results, yes.
You would agree that hiding a body so that it naturally decomposes before it's located is a great way to conceal evidence.
Objection, Your Honor. This falls outside of the scope of medical exam.
I overrule the objection.
Got to answer.
I don't know the intent of individuals in circumstances like this.
I'm not asking about the intent. I'm asking whether you would agree. it would
Whoa,
be a
that's
great
scary,
way to get
Dandy.
evidence from you.
It potentially is. I have no, I don't think anybody can determine when or whether a body will be found.
Sauce.
Yes, Your Honor. Dr. Turner, you've been presented by the state with several different medications, right?
Yes.
Is there anything different besides dosage, between the active ingredient in adult diphenhydramine and children's diphenhydramine?
No.
Dandy.
What about acetaminophen?
Same thing.
You were asked if there were many medications that contain both for children.
Thanks, Mel.
Is there evidence that William received these 2 medications from one single dose of one medication?
No.
You were asked if there was a label that said "do not use for children," right?
Yes.
Why would that be present on an adult medication?
Because of the dosaging.
But the same medication is available in other medicines designed for children?
That's correct.
There's
She's
also
a lot softer
question about
sounding now.
if there's a warning to keep out of the reach of children. Is that right?
Yes.
Should we keep children's medicine out of the reach of children as well?
Yes.
Why is that?
For safety reasons.
You were asked a lot of questions about the dosages of each, the recommended dose. Is that right?
Yes.
Is that right?
Do we know what
I think we
doses
heard it.
you received?
No.
Do we know which drugs you received? Which name brand drug you received?
No.
Do we know if it was a combined medication between one medication?
No.
Do we know how many doses William received?
No.
I wanted to ask you about a follow-up question about the animal scavenging.
Yeah.
Something about the scene of the crime scene of the location of the body was found that you found illustrative or important?
Well, the skull was separated from the torso, and you could see the effects of decomposition underneath the torso and surrounding the skull. The mandible was separated from the skull. Other things related to the scene include before the skull was removed from the scene, it was photographed in place, and the skull was lying on the left side with the right zygomatic arch area exposed.
Is that significant to you?
It's in keeping with the animals having access to the right zygomatic arch and their scavenging.
Mhm. Fair, but that means nothing. I mean, that means nothing.
Welcome.
Thank you so much. May she be excused?
Yes, Your Honor.
Yeah, sure.
Okay, you're free to go. Thank you. All right, any other evidence or witnesses for the defense?
Thank you, Honor. That's rest.
Okay. Is there gonna be any rebuttal evidence for the state?
No, Your Honor.
Okay. All right, ladies and gentlemen, the evidence in this case is closed. The next step in the process is for me to talk with the parties outside your presence regarding the charge, which is the law that I'm going to instruct you on, and then do the closing argument. And we also have this is a long explanation, but we have a hard stop today at 4 o'clock, and it's already 1. We haven't taken a lunch break yet, and then I've got to meet with them. It'll take at least an hour, and then closings will be at least an hour per side. So bottom line is I'm gonna let you go early today, and then we're gonna start back in the morning at 9 o'clock. Please be here on time.
All right.
If you have any issues, car trouble, anything, please call us immediately and let us know so that we can try to get this wrapped up. We can't start until everybody gets here. So at 9 in the morning, we'll be ready to begin the closing arguments, followed by the jury charge, and then you'll get to start the deliberations. So hopefully, my goal is for you to have the case by lunch. But we can't do that unless everybody's here. Okay. Any questions? All right, same rules remain in effect. Keep hanging there, keep with me. We're almost at the end.
This is what, day 4?
Overnight. There is a new parking code this week. We will get that, Jocelyn will get that to you to make sure your parking is taken care of. Okay? All right, y'all have a great night. Please be here tomorrow morning by 9 o'clock. Thank you.
So the jury gets it tomorrow. I do believe that on Friday I'll be doing a live with the alternate corner. And this is going to be on the Karen Reed case. So subscribe, make sure you hit that bell and the thumb.
All right.
Get notified for what I'm doing this week.
I want to go ahead and take a lunch break, and then let's meet back at 2 o'clock, and we will do the charge
Okay.
conference at that time.
I just want to
Caroline is-
see, let's see. There's a little bit going on. Let's see. Oh.
Your Honor, the first case is Kellum versus the state, is a Supreme Court of Georgia opinion from 2016. It deals with a case where a defendant was charged and convicted with malice, murder, and cruelty to children arising out of the death of a 17-month-old. In that case, the court denied giving the jury charge on accident, and the defense appealed. The Supreme Court agreed with the trial court, noting on page 4 of the opinion, kind of midway down in the second paragraph, An affirmative defense of accident generally requires
So about
an
45 minutes
admission
left,
by the
guys.
defendant that they committed
And
the
then
act that caused
tomorrow,
the victim's death.
closing
At
arguments
the
and the
least, the
jury.
defendant's theory of accident, whether it be supported by defendant's admissions or some other evidence, must be consistent with
Have a good night,
corresponding
Mel.
evidence of cause of death, which was not the cause here.
But we don't know what the cause of death was here.
Thanks for being here.
In our
Have
case.
a great
Correct,
night,
but-
man.
And the issue here is that the reason I provided this case, Your Honor, is for the proposition, the defendant has to admit to doing the act. And so you can't raise the defense of accident if you haven't admitted to doing the act. Accident is an affirmative offense that goes to the intent. The defendant is saying, I didn't form the, while I did the act, I didn't form the requisite intent. And so it goes on further. An affirmative defense is one that admits to doing of the act charged, but seeks to justify, excuse, or mitigate it. Accordingly, if a defendant does not admit to committing any act which constitutes the offense charge, he is not entitled to a charge on the defense of accident.
What did,
Then
Okay,
just
go
a
ahead.
little bit further, the last paragraph on page 4. Accordingly, in order to claim accident, it must be established a defendant acting without criminal intent, was not engaged in a criminal scheme, and was not criminally negligent, i.e. did not act in a manner showing an utter disregard for the safety of others who might reasonably be expected to be injured thereby. In count 2 of the indictment, this is probably the only count the defense would even have a possible argument of accident, a possible admission of doing the act. Ms. Black is charged specifically, and again, it has to be to the crime as charged. She is charged specifically with maliciously causing William Hamilton, her child, cruel or excessive physical and mental pain by failing to seek medical treatment for William. You can't accidentally not take someone to the hospital, and it can't be as a result of criminal negligence. So as the court says here, a manner showing an utter disregard for the safety of others. Here you had Teresa testifying that she knew something was wrong with him, that she should have done something, that he was gagging, lethargic, didn't want to get up, didn't talk, and she didn't take him to the hospital. That's criminal negligence, Your Honor. It's not an accident. As to the remaining charges, count 4, cruelty to children, did maliciously cause William Hamilton, her child, cruel and excessive physical and mental pain by administering a substance or substances containing diphenhydramine and acetaminophen. There's been no admission or evidence that she admits to giving him either of these substances, and in fact told the police in her statement that she didn't have cough syrup.
Why did she lie for
Was a
20 some
lozenge,
years?
and that was so he had something to eat.
That's a problem.
A lozenge isn't going to have diphenhydramine and acetaminophen, certainly not in an amount that would cause a child's death. There's been no evidence of that. So count 4 would not be, accident would not be appropriate. There's been no admission of the act. Count 5, aggravated assault. There's been absolutely no admission of the act of striking the child or causing injury to the child. So accident would not be appropriate. And finally, count 8.
How do they even live with themselves after doing something like this? I mean, really, accident, not an accident. How do you live with yourself?
Lie about them being alive when you know they're dead. That's not an appropriate charge. So we're really only discussing count 2 here, the concealing of a death or failing to take him to the hospital. And that's just not appropriate for an accident charge where she's been criminally negligent, Your Honor.
all right, Mr. Bozarth, do you agree that the only potential charge in the indictment would be count 2 for the accident
Well, I think
issue?
I think that's certainly the leading charge where this would apply, but I don't think it's necessarily the only charge. I think there could be evidence that the jury could find that William received acetaminophen and diphenhydramine at a certain level and may not believe that Ms. Black gave it to him with the intent of causing severe injury, which is what's required by the statute.
Thanks
We
for
believe
putting
that
that in there,
defense is
Dandy. I
harmless
appreciate
based on
that,
the
Frank.
evidence that's been presented by the state. With the failure to seek medical care, the charge speaks about no person should be found guilty of a crime committed by misfortune or accident, but there was no criminal scheme, undertaking, or intention, or criminal negligence. I don't think the fact that William passed away is per se evidence that this is at least negligence or at least intentional. And this could be accidental, that she didn't know there was anything so serious that required medical treatment. And therefore it is relevant.
I suppose couldn't the jury, Ms. Hodder, find that there was something other than the Tylenol or Benadryl going on with this child that might have caused the death?
That does not go to accident. Accident must be related to the intent for the crime she's been charged. That's just a defense that she didn't commit the act that she's been charged with. And that would be the appropriate argument. And Wilson versus the state, the Supreme Court of Georgia decision from 2005 goes to that very point. If you'll turn to page 3, kind of towards the bottom, midway, a little further down, appellant's testimony suggesting the victim.
Doesn't seem like the defense has been making many points.
Okay, I see it.
That the victim died from a drug overdose and denying having taken any action that caused the victim's death by manual strangulation does not involve homicide by accident, but only a death from accidental means not attributable to any conduct, culpable or otherwise, on the part of the defendant. So accident is not just some, mere charge that goes to, well, this child could have died by any sort of plethora of unknown means. It has to be directly related to the intent element for the crime for which she has been charged.
Which it
And there's
is.
been no admission.
The admission was she didn't take him to seek medical treatment.
And that was criminal negligence.
Yeah, all right, so
Based on, it's not criminal negligence.
The defense makes no sense to me.
she's saying that you can't accidentally not take the kid to the doctor. You can't make a decision
Exactly.
to not seek medical treatment by accident. It's an
Exactly.
affirmative decision to not do something, is what she's
Yes.
arguing.
All right. Is the state saying then that it could be negligence that doesn't rise the level of cruelty to children? Because then I would agree with that portion.
No, I'm saying that as the Supreme Court has held, that criminal negligence is not a basis to give an accident instruction to the jury.
Then I stand by what I was saying. No one's saying that it was negligent either. No one's saying that it rose to the level of negligence. The defense certainly isn't. The fact that the child died and she didn't take him to the hospital doesn't mean it was negligent either.
Oh, exactly, Dandy.
The hospital, is that what you're saying? Right.
The issue with this, and why I think it's appropriate here, is this indictment. I understand the state through some questions.
But he doesn't even make sense. It's just like wah, 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 wah.
The child received a toxic level of acetaminophen and diphenhydramine, and she's committed cruelty to children for not taking him to the hospital for that very reason. But we don't know. There's so many reasons this could have happened. That this can be confusing to the jury.
Not
If she
so
didn't take him
much.
to the hospital for treatment for anything, they may find that that it could be for any cause. And I think that's why it's appropriate. We stand by the request for the charge. In the Keller case, I'm sorry. This is where the victim's death was caused by tremendous blunt force trauma that could not have been a result of the accident that the defense was proposing. I think the potential of an accidental overdose on acetaminophen or Tylenol does give rise to this being appropriate.
Let me ask you a question, Mr. Bozar. What did, let me find her statement.
It's almost like the judge is a little irritated by his antics.
Here we go. What did your client admit to doing? And let me just look. It looks, this is what I can tell. I know that something was wrong. I wasn't able to feed him right. We were just kind of sleeping on the bus benches. He wouldn't want to talk, wouldn't want to.
And yet she had a place to stay and they were staying on bus benches?
Something to eat.
Is that my understanding?
Didn't seem to help much. He just kind of didn't want to do anything, so we ate stuff out of the garbage can.
I think it's that she didn't know that he needed medical treatment sought, because she didn't know what was wrong with him.
So I guess the question is if, let's see, hold on. Can you accidentally not realize that someone's symptoms warrant medical attention? I don't know if you decide, you make a decision one way or the other.
It's a disregarding.
Well, either you decide, you either say, I don't know what to do, which is what she said in this case, I didn't know what to do, or you decide to take somebody for help. But I don't know if deciding not, or saying I didn't know what to do means, I don't know if that's accidental. I just want to make sure that the evidence supports whatever charge I'm giving, and I'm not sure. Can you accidentally misinterpret the signs and symptoms? But she never said, I thought he was okay. I thought he would be fine. I don't know.
It says accident as defined in 16-2-2 is not, death from accidental means not attributable to any conduct, culpable or otherwise, on the part of the defendant.
So criminal negligence would be culpability. If she gave him that Tylenol and Benadryl,
Mistakenly.
an accidental overdose, mistakenly, does that require a charge for accident if it was an accidental overdose?
If the defendant got up there and said, I thought I was giving him a bottle of Flintstones vitamins, and it turns out it was a bottle of acetaminophen, that would be an appropriate accident charge. There was some mistake of fact. There was no decision or culpability on the part of the defendant. The accident is a defense that goes directly to whether she formed criminal intent. When she said, I knew there was something wrong, and she made a decision not to take the child for care, that is affirmative conduct. There is no accident there. An accident is an appropriate.
I know that something was wrong. He wouldn't talk, he wouldn't get up, and I didn't know what to do, so I figured, okay, he's just hungry.
What the defense wants here is a general instruction on accident, because they want the jury to think about, well, this child could have died by accident.
Right,
And that's not appropriate.
Yeah, just for the admission portion, I point to.
I'm sorry, what did you, I didn't hear the first part.
Sorry, as to the admission portion of what we've been talking
Okay.
about, she doesn't admit. We point to Johnson v. State, 316.
Do you have a copy of that case by chance?
I have that electronic.
All right, go ahead.
316 GA 672. So 2023 case.
316 GA 772.
672.
Okay. And
2023.
what does it say?
It's reviewing the court's refusal to give an accident instruction, and saying that current law is clear that a criminal defendant is not required to admit anything in the sense of acknowledging that any particular facts are true in order to raise an affirmative defense.
But there has to be evidence. It doesn't have to be through an admission and testimony,
Right.
but there has to be evidence at some phase in the trial.
Right.
There is evidence that he received Tylenol and diphenhydramine, whether it's from his black statement or otherwise. There is evidence.
But you're saying there's no evidence that she gave it to him.
I'm not saying that. I think there is evidence that she gave it to him. In the trial, I mean, there has been evidence presented that he had that administered. There's been no other evidence that anyone else was around and caring for him.
Okay.
I think there is evidence.
Okay.
She gave a statement. She gave a statement to police and flat out denied giving him the medications. That's a different scenario.
They can view that as believable if they like. I'm sure that's the state's theory. And
All right, refresh my memory. What is the evidence, just because this has been going on for quite a while, what is the evidence that she gave him Tylenol and Benadryl? Who said that?
She never did, Your Honor. All she said.
She didn't. But what,
It
but Mr.
being present in his.
Just the mere presence of it in the system, you're
Right.
saying is evidence that she gave it to him?
yes.
Okay, let me get back to that one. Let's move on.
And the other objection the state would have would be to giving the defense's non-pattern charge for concealing a death. And we would ask that the court give the pattern.
Mr. Bozarth, I'm not inclined to give that non-pattern charge. We talked about that earlier.
I'd like to go back into it.
Yeah, sure.
Ready to hear from.
Of course.
I
It's
would-
just that I wasn't inclined to do it. I'm happy to hear from you.
Yeah, Roach,
Yeah. Thank you.
really focus on the Walker case, Judge.
Well, this is Duncan.
The third one there.
Oh, well, okay, sorry. I just thought it was all one piece.
No,
Okay.
actually,
That's okay. All right, go ahead.
In Walker.
So this is like the fourth day, right? It seems like not very long for all the confusion that's going
Page
on.
3, they're not numbered, but it is page 3.
Or am I mistaken?
Beginning in paragraph B. This is a case where a person is challenging the sufficiency of the evidence for a concealing charge. The person had been convicted of malice murder, I believe, and that was not overturned, but the concealing portion was. In the middle of that paragraph B, on the left side of the page, middle of page 3, it says that the state had to show, quote, by concealing the death of Ramona.
Yeah, that's what I thought. So I wonder why there's all the confusion. Why is she saying that it's been such a long,
This is where they start to break.
I
it
mean,
down
OJ
into
went for months and
different
months.
prongs. The next sentence is, that is, the state had to prove that Walker actually concealed the fact of her death, and it had to establish that his doing so delayed or otherwise hindered discovery. Goes on to say that the gravamen of the offense is conduct that hinders a discovery. That person has been unlawfully killed by concealing that death. The next line of next paragraph gives a list as to concealing the fact of death. We have found sufficient proof that the element in previous cases in which evidence showed, for instance, the body of the deceased was removed from the scene of death to a remote location, that the body was burned, the body was dismembered, Persons with knowledge of the death were prevented from reporting it by threats or intimidation, and that persons in search of the deceased were misdirected intentionally. All of those are an affirmative act. Every one of those. In this case, the state says that the element of concealment is satisfied by proof that Walker moved the body of Ramona from the floor to the sofa on which she was found, and that he turned off a nightlight in the apartment before leaving. About the movement of a body to the sofa, we do not doubt that even moving a body a short distance might, in some circumstances, amount to the concealment of the body. That is showing that it did require that movement. They said it was likely, it could be fine if it was, albeit slight movement, but it was an active step.
Kind of like kidnapping just requires.
That's
slight-
right.
Okay.
There isn't a case. And again, if I just haven't found the case and the state has it.
I'm going to keep my eyes peeled for a court case again tonight. I missed one last night. It was only about 20 minutes, but I'll keep my eyes peeled again tonight.
Concealment, literal and act.
23 years, and this is the best I could come out with. That tells us a lot.
It's clear that this is needed because the state still disagrees that that's necessary. The state believes that it is fine to just leave the body there. I understand the court denying our motion for directed verdict because the court found there could be evidence that somebody dumped the body there. Gary Harris saw a car. I understand the court's position in denying that directed verdict. But if the jury wants to believe that Gary Harris saw Miss Black and some accomplice in a car drop the body, that's fine. That's concealment. That's moving the body to those woods and dumping it. That is concealment. But they need to know they can't just find the body was left where he passed and walked away. That is not an act of concealment. That is leaving it. And I'll go back to my other argument about murdering someone in a remote location. If you meet somebody in the desert and you shoot them and you do nothing else and you just turn around and walk away, you have not committed concealment. And if you have, then the elements are not distinguishable anymore. And the legislature has set up separate elements for these crimes. Murdering in a remote location is not concealment. There's still the act of concealing that is not present in this case, and it's not present in a single case that cites the Georgia statute.
There may not have been any cases where someone is alleged to have left a body in the woods for 20 years for it to decompose and lied about the existence of the individual, further contributing to the ability for it to decompose, for evidence to disappear, and all of those things. I mean, just because there's not a case with this exact scenario doesn't mean.
The court is adding a lot of extra stuff that doesn't fit the statute, to be fair.
Okay.
For the fact that it was 20 years before the body was identified is really not relevant here. It's for what's happening here. And the lies in Charlotte and Alaska and Arizona are not relevant either. Those are not in the venue of DeKalb County. The fact that the body decomposed, that's not the same act of concealment. It requires concealing that hinders the discovery. And the body decomposing, because there have been cases of someone getting killed in a remote location and being unidentified. We all know that. Or not being found right away. If this would be allowed, every murder in a remote location would automatically be concealing with no additional proof.
So you're saying that the lies and the cover-up all has to take place in DeKalb County for it to?
Absolutely.
Do any of those cases, the 34 cases you read, say that?
Yes.
Show me.
So and I think we left them on the printer, the bottom two that I cited in my proposed charge.
I don't know. Do you know the names?
I do.
The ones you just gave me?
No, Your Honor. Here, if I can just give you a copy of my proposed
I
charge.
just have a hard time to believe, really hard time believing that our appellate court is intended for something like this not to be, or our legislature intended for this not to qualify as concealment.
May I respond, Your Honor?
Well, let him finish his argument first, and then you can. Go ahead.
So the bottom two cases, Waldrop v. State and Clary v. State. I'll start with Clary v. State. This was an accomplice murder. Somebody murdered someone in South Carolina and then transported them to Georgia. The defendant in Georgia, who was only tried in Georgia, venue was proper here because the defendant burned the car containing the victim in Georgia, despite the fact that an accomplice killed the victim in South Carolina. Venue's not proper in South Carolina there, despite where the death happened, because the concealment happened in Georgia. Waldrop v. State says that venue was proper in
It's
two
just a
counties
bunch of semantics.
because the victim's
I
body
mean,
was killed in one county and transported in
I'm
one
not
county,
seeing a
and
defense
distributed
here.
in another.
Not yet.
The here is venue was proper in both counties because the act of putting that victim in the car and transporting in the first county was its own separate concealment. It wasn't proper there just because the death happened. It was proper because concealment happened in both counties. A lie is concealment, and that is only proper where that lie took place. They could have charged her in Charlotte for concealing the death of another. They didn't. Well, they could, whatever.
I'm just not seeing it. I'm not seeing one thing that's saying that this woman's innocent in any way, shape, or form. You know, when these people get away with this for 20 some years, I mean, we've got to use common sense in there as well. I mean, we can't just listen to verbal diarrhea and accept it. We got to throw in our own common sense.
That's just not for us to consider. She can't be found guilty of a charge or of an offense that potentially took place in Charlotte or Alaska. That is a crime that took place there. It does not relate back to the body like the special circumstances in the homicide venue. It's separate.
I mean, the whole fact that, what about the fact that she didn't report her child missing? She didn't do anything.
Exactly.
I'm just having a really hard time wrapping my head around this.
That can be an act that society looks down on, but it's not the charge of concealing the death.
What is the code section?
It is 16-2-2, Your Honor.
2-2?
Oh, I'm sorry, no, that was accident. Is it 16-10-31?
Yes.
In the Waldrop and the Clary case, where the venue was proper in 2 counties, what were they charged with? Concealment only?
The Clary case, the person in Georgia was only charged with concealment.
So here, okay, let me see. Where the indictment in this case. So many papers. Hold on. This is the charge. All right, here we go. The indictment says.
That's the thing, Dandy. Like,
Conceal the death.
there's no reason. Who just leaves their kid, you know,
By leaving the body of William Harris,
nothing that they're saying is making any sense at all.
She left the body in DeKalb County. That's where the body was found, right? Or we don't know that she left the body in DeKalb. Is that what, I'm not quite sure.
Or we're mixing up the two issues, Judge. The leaving the body portion, I'm not raising the venue argument for.
Okay,
It's the lying portion.
okay.
That's a venue problem.
Well, but isn't it, if it's and, it's or kind of thing? Like, in other words, if that's how it's always, the way they draw the indictments is if the state proves that she did one or the other.
That's fine, right? That's fine.
Right?
Because they can find either one. They don't have to find both. I'm not saying that. But to find the lying portion, to find any crime, venue has to be in DeKalb County. That part's clear. And the line, which would be concealing, which is a crime, has to be found in DeKalb County.
Okay, but the way they charged it is by leaving the body in a wooded area. That was in DeKalb County. Whether he died there or she dumped it there, the body there. That happened, that was in DeKalb. The body was left in DeKalb County.
Yes.
So if the jury believes that she was responsible for that by leaving the body in the wooded area, I mean, I think just based on how they charged it, I think that should be sufficient. And perhaps the appellate courts might disagree with me, but I'm having a really hard time finding a way.
Judge, I think we're mixing up issues here. I'm sorry to interrupt the state. I will let them speak, but my point of bringing up the venue problem was the second sentence.
I understand that, but that's your argument about why.
I would
it
think so,
can't be lying
Dandy.
About his whereabouts. But what I'm saying is the jury has to find one or the other.
That's right. They could find concealing by leaving him
Yes.
if they believe they dumped him.
Right.
I'm fine with that.
Okay.
As long as they know it takes an act of concealment and that if you believe the lies happen, they happen in DeKalb County. That's the law. This is no longer a directed verdict. This is me saying they need to know that she's charged with lying. They've heard a whole trial of her lying. They need to know if they're going to convict her based on that prong of this indictment, that it happened in DeKalb County. They have to find it happened in DeKalb County.
And Your Honor, the jury will receive venue instructions. They'll receive the general venue instruction. The state has requested special circumstances of venue instructions. These are all patterned. And that is the appropriate way to advise the jury about how to make these legal determinations. They should be given the plain language of concealment and then venue separately, as with all the other charges in the.
This seems like it should be a lot easier than what they're making it.
Anything else?
I think it's.
Anything else?
This charge in particular is exceedingly confusing on venue. It needs to be clarified.
Good
Because
Lord.
The entire trial, evidence was brought up about her lying about his death, and none of it ultimately matters in this case.
Really?
Except she probably lied to, there is evidence that she lied to Ava and would have had to have lied to others if she
That-
did in fact.
That's not evidence. The fact
Oh,
that she was
exactly.
a bus driver.
Reasonable deduction.
Guys, you can't argue. talk about
Right?
it.
Circumstantial evidence is evidence.
Okay.
It's not circumstantial evidence that she probably lied to someone else. You have to show the evidence of that lie.
I don't even know why this guy, I mean, the judge keeps going, but no. And this guy is not going to convince her to her way of thinking, like to his way of thinking, because it's messed up. It doesn't make a lot of sense what he's trying to.
I'm
twist here.
not gonna give a non-pattern charge. I think there's a lack of law on this issue, probably because this scenario hasn't been addressed. So, the appellate courts, if they have the opportunity, can clarify if they think it's appropriate, if I'm misinterpreting it, but I'm not gonna give that non-pattern charge. You can argue whatever you want about it, but I'm not gonna give that charge.
So there you go.
So,
And Your Honor, just for the record, I understand the court's ruling.
of course.
The state will be arguing in closing that you can believe that Teresa woke up, William was there, and that she never even touched his body and walked away, and that she's guilty of concealing, which is not the law. That's what's going to happen in this trial. That's our.
Oh, whatever, buddy.
Okay, I disagree, but I understand that's your position and you preserved it for the record. So,
So there.
all right, and as far as.
Chew
the
on
other
that.
issue then from the state, and I'll get to your additional objections, is the issue of the accident defense. Hold on, let me give me something.
Maybe he's related to Gail Brooks. Just saying.
Based on the cases, it looks like the law does require her to have admitted some type of conduct for the accident charge to apply. And under the facts of this case, I don't think that's happened. Do you want to be heard any further on that?
We stand by what
Okay.
we've argued.
Okay. All right, so I'm not giving the accident charge, and I'm also not giving the charge on the non-pattern charge on concealment. Excuse me. All right, any objections? Were there any further objections from the state?
No, Your Honor, just some tailoring.
Okay, any objections from the defense?
I think I have some tailoring as well. There's
Okay.
some that I think may no longer apply.
Hold on one second.
Wonder if this guy's giving her a headache as she rubs her forehead. Tomorrow's going to be interesting. How long do you think the jury will be out? Do you think this is going to be a fast turnaround, or do you think it's going to be a few days? I mean, as we know, I've seen very, very little, but I would think it's not looking good for the mom. Whoa. What happened there? Exit stage left. Hmm.
This isn't this wouldn't be a crime that was necessarily committed in more than one county, so they don't know and can't prove it. That is covered in the general venue charge. This is not an issue where there was a crime that happened in multiple counties, so any of them are good enough. They don't know which one it is.
All right, I'm looking, hold on, I'm looking, I need to find the email with the venue charge.
Yeah, it's, you know, I'm not seeing that there's a lot of things written in stone, but everything that, you know, that circumstantial evidence is not looking good. I mean, it doesn't look good at all. No one wants me on their jury. No, no.
Do you have the proposed charge? Something's going on. No, okay, thank you. Okay.
How many computers has she got? 1, 2, 3, and then the one underneath.
Okay, I thought that was part of the venue charge already.
It's a special circumstance, special circumstances.
Yeah, it's not looking good on,
Further.
from where I'm sitting, Dandy. It's just not.
Okay. I'm comparing it. It's already included in a prosecution in any case in which it cannot be determined in what county crime was committed. Venue is proper, may be proven in any county which the evidence shows beyond a reasonable doubt that it might have been committed. That's part of my general pattern charge on venue. It's 1.51.10. Yeah. That's part of it shows up in the charges 1.51.10. Let me see if.
So is this
Oh, wait a minute.
defense lawyer, is he just proven to be not the best at his job all the way through?
You might have emailed Caroline the wrong.
Brutal.
kind of just said twice.
It is.
Yeah.
What are these people? Adam Montgomery.
General instructions.
Okay.
Satisfactory.
There's another example
I'm reading
of
this, I'm like, this sounds very familiar. I read this all the time, so, okay. That's yours. All right, what?
that little
let's
doll
talk
has not been
about
found yet. I hope they
cleanup.
don't run into these kind of issues and stupidity.
All right. Page 5, witness attacked.
Pull it dry, Your Honor.
Thanks for all your help, Andy. You've kind of filled us in.
Okay.
Much
We
appreciated.
added- oh, let me go back to 3. We added stipulation number 5 about William Hamilton Senior. Were those dates correct? I think they are.
Yes,
They
Your
look
Honor.
right.
No objection.
Okay.
Oh, it's March, that's March 2nd.
March 2nd? Okay, we'll change it to March 2nd. Okay.
So yeah, there was what, nothing as far as betting anywhere around
Did the court
him?
take judicial notice of anything yet?
No.
I'll withdraw
Withdraw what?
the request that you give the judicial.
Okay.
So the fact that
Alright, so
she
witness attack,
lied
top of
about
page 5 is
him
out, and the top of
for
46.
23 years tells me almost everything I need to know.
Witness supported.
I withdraw.
Okay. If I skip over any that you think need to be cleaned up, let me know. All right, page 7, the defendant's statement. We take out the parentheses because she was in custody when she made the statement. Correct?
She was in custody.
She was.
Correct, yeah, she was. So it should read, the statement was voluntary, comma, and, should we take out the state, or just say, we just put a comma, take out the parentheses, or do I say if the statement was given in custody? Because she was in custody.
I think you read the whole.
Read the whole thing. All right, just take out the parentheses on that one.
It is really interesting to see how they deal with all of these issues behind the scene, even when the jury's not around.
With the child, Your Honor, between the
Okay.
defendant and child.
All right, defendant and the alleged victim then. And cross off witness.
There was also evidence of the gun being pulled on the father.
But that wasn't for prior difficulties, it was to, it's for her
That
credibility.
was,
and her
yeah, that was something else. I'm not gonna, no. And I think I
No.
told the jury to disregard that anyway. Didn't I?
No,
Oh, I gave a limited instruction? Oh, because it was only,
No,
it was
Jeff.
introduced for the limited purpose. Okay. Well, it all runs together after a while.
I think the second parentheses for witness needs to be struck through as
Yep,
well.
yep.
And the reasonableness of any alleged fears by the defendant or alleged victim, that goes towards a self-defense.
Agreed, okay. Nothing about prior convictions.
Withdraw.
Okay. Parties to a crime, states withdrawn. All right, bottom of page 13, I think what's highlighted is fine to leave in.
The felony murder are specifically attached to the cruelties of the indictment
Yes, Your
Okay.
Honor, aggravated assault should be removed.
Thank you.
twice.
Yep. In both, okay. So child cruelty is a felony, right? Is singular,
Yes, Your Honor.
same in the bottom paragraph, felony of child cruelty, okay.
I just, in my mind, I'd be a lot happier
Language
if
of the indictment, it's charged
the
as
defense had to stick
cruelty to children.
to actual
Yes,
facts
we'll
versus
change
being
that.
able to throw stuff at the fan.
Cruelty to children.
I find it disturbing that they can get away with like
For
just
both.
throwing
Yes.
anything out. Not my monkey, not my circus, but wow.
All right, all right, let's talk about aggravated assault on page 14.
Tailored to offensive weapon, strike out deadly weapon.
Oh, hold on, let me see what it's how it's charged. Use offensively, okay, offensive weapon. All right, and then take out the committed an act that placed the person in reasonable apprehension and just go with the first parenthetical.
Yes, Your Honor.
I'm gonna have to watch that, Dandy.
All right, then cruelty to children.
We charge cruel or excessive, so both,
Child cruel or excessive.
and then physical or mental.
Malicious, okay, hold on, maliciously caused. Cruel or excessive and physical or mental pain.
Yes, Your Honor.
Okay, so could we change those to reflect that? Not giving accident over defense objection. Venue, not giving the special circumstances because it's covered. Is that correct?
Yes, Your Honor. Well,
What about
except,
others?
I'm sorry, the criminal homicide.
Wait a minute, criminal homicide, okay. But leave in, if a dead body is discovered, that last sentence, because that's not included in the first one.
So, the whole paragraph for criminal homicide special circumstances, a criminal homicide shall be considered as having been committed in the county in which the death was inflicted, if it cannot be determined in which county. The whole.
So that's the special circumstances one.
Yes, Your Honor, I
Okay.
amended and did it.
There were two, okay, so the first one I'm not doing because that's included, okay, got it, so we're gonna leave this in, okay. Leave in.
You're okay, Jazz.
Okay. All right. The only other thing that was highlighted was on page 17, but that looks okay to me.
That's correct.
All right. Any other issues or objections?
Not from the state.
Okay. Alrighty, then we'll start up tomorrow morning at 9 with closings. So each side has 2 hours, is that right?
Yes, Your Honor.
Okay. All right, so we'll probably do closings, see what time it is, break for lunch, then come back and do the charge and deliberations. That's what I'm.
Stop, Jazz. No.
Okay. Alrighty, then you all.
Okay, then. Well,
I just have a cert.
there we are. There we are. So I will set up for tomorrow and we'll catch those closing arguments as well as do a jury watch and see how that goes. So she was just saying it sounds like they both get 2 hours each. And then after that, deliberations. But she was also saying that she was hoping to have the jury in by noon, done by noon and sent back. So we'll have to see how that goes. So you know what, guys? I'm going to leave it there. And thank you very much. Don't forget to subscribe, like, and share. And I'll see you guys in the next one. See you tomorrow. Bye.